shall we shall we shall we begin?
Yeah.
We have the main people here. So on behalf of this program, it's not an organization called Center for Legal Change. Let me welcome all the very distinguished panelists that we have. And I'd just like to, my name is Mohan Gopal, and I would like to begin by just saying a couple of words about the program and then request Professor Vidyut, our moderator, to take over and moderate, and then I will speak as when my turn comes. As we all know, the question, are our courts delivering justice, is actually a very widely debated question for many years inside and outside the legal system. There have been very many discussions, rightly and appropriately, on asking this question from the point of view of gender justice and poverty. So are courts delivering justice for women, and are our courts delivering justice for the poor? A question that has not received adequate attention, and this may be perhaps one of the first occasions to open up this topic, is the question, are our courts delivering justice for the caste marginalized? And so we have a very distinguished panel to help us open up this topic and look at it. And the panelists here are well known for looking at systemic and structural issues and problems. So our objective is clearly not to look at personalities or be overwhelmed by personalities of judges or lawyers or litigants, but to look at the structural issues and to ask the question, are courts delivering justice for the caste marginalized? Clearly, they are not, because a very large section of the victims of the justice system, namely the first victim is those who are wrongly accused and framed. And our last discussion was on this issue of framing of innocent people by the state. So those who are framed and dragged into courts and for needless reasons, for simply exercising their freedom of speech. And we have Mr. Kancha Elaya, who is a very noteworthy and example of someone who's been harassed in this manner. And then the next step is then once that wrong framing takes place, then as under trials, the very large number of people, 70% of the people in our jails are under trials, and very large proportion of them are from the scheduled caste, scheduled tribes, and socially and economically backward communities, and also very poor. And so clearly, the vast majority of those who are in jail as under trials, who are victims of the system and its failures, are also from the lower caste and the marginalized caste. I don't like to use the word lower, so we use the word caste marginalized. And also in terms of the convictions and sentences, we have not had a study, but we clearly know that a lot of the harsh sentences that are delivered by our system goes to the poorest. And we also know from a lot of statistics, including National Sample Survey statistics, that the vast majority of poor are SC, ST, SC, BC. And so, therefore, we know that the brunt of the failures of the justice system are borne by the caste marginalized. And on one hand, going further, we also feel that one of the reasons for this, the hypothesis, is that the concepts of justice of the caste marginalized are different from those who, the privileged, who are occupying top positions in legal education, in the bar, and on the bench. And that leads us to the next issue, that the lack of representation, lack of voice of the caste marginalized in these various realms of the legal system are also very, very important reasons why the legal system is not working in a sensitive way or in a just way to the caste marginalized by all evidence that is available. So we thought we will use this session not so much to look at it from the point of view of the legal system looking outwards at the caste marginalized, but start by looking at the judicial system, the courts, and their performance from the point of view of the caste marginalized, and then make that our fundamental basis. And then in another session that we will organize, we will actually look at the problem from the point of view of the judicial system to see what the problems that we are identifying today are and how we will deal with those problems. What I'm hoping to do at the end of this discussion, which is in two parts, as our moderator will explain, is see if we can draft a 1 or 2 page letter identifying the main issues faced by the caste marginalized in relation to the judicial system, whether it's a concept of justice or it is the way that justice system operates, and send it to the Chief Justice of India and the other judges of the Supreme Court, Chief Justices and judges of high courts, so that they will hear from these discussions today. We'll start a process where we will start to convey to them that there is another perspective that is not being heard, and then we will start a process by which hopefully we will start to influence the way in which the legal system evolves to be more just to the caste marginalized. And we are very lucky to have the time of some of the most distinguished voices in this regard, very experienced directly with the judicial system. As I said, Professor Kancha has borne the brunt of challenging the caste order in terms of the law being used against him. Mr. Wilson Bezwada has been a litigant in very important constitutional law cases, and has used the courts as a very important instrument of justice while seeking justice for the Safai Karamchari community of our country. So these are people with vast experience, and I look forward to hearing from them. To Vidyut, Professor Vidyut, who is a very distinguished young academic at the Government Law College in Kozhikode, with doing his PhD on justice. In fact, I must say that it is our discussion on its PhD topic that started the idea for these webinars, and widely read and widely knowledgeable about a variety of issues pertaining to justice, and very committed to the cause of social justice. So over to you, Professor Vidyut.
Thank you so much, Professor Mohan Gopal. I'm very happy that you have introduced the theme of today's discussion very nicely, and also you have indicated the significance of this discussion being the first of its kind in the history of India, we believe. And I'm very happy. I'm not going into the introducing that theme because Professor Mohan Gopal has already done it nicely. So I'll just, only for the sake of formality, though all the panelists here are well known in India, but just for the sake of formality, I'm just introducing them. Firstly, Professor Kancha Elia Shepherd, who is a leading figure in the ideological movement against the Indian caste system and has been instrumental in internationalizing Dalit marginalization issues and remaking Indian human rights thoughts for a long time. He's a political theorist, a prolific writer, and activist for Dalit rights. And he was a professor and head the Department of Political Science, Osmania University, Hyderabad. He has written very extensively on these issues relating to marginalized communities, and he is influencing a lot of people and encouraging many of them to enter into the cause of uplifting the so-called marginalized communities, caste marginalized communities. I welcome you, sir, for the panelists, and thank you so much for being here to present a discussion on it. And secondly, I would like to introduce Beswada Wilson. Again, I don't need to introduce him. He's famous in India as the recipient of the Magsaysay Award, Ramon Magsaysay Award. in July 2016. He's also an Indian activist, one of the founders and national convener of the Safai Karamchari Andolan, an Indian human rights organization campaigning for the eradication of manual scavenging. Recognizing his community work, Ashoka Foundation nominated him a senior fellow, and he has been contributing for the betterment of the manual scavengers in India, and also executing and implementing the laws relating to them, which has been violated quite frequently in Indian experience. Welcome, sir. Welcome to the presentation, and we hope we could hear you different perspectives from your side. And thirdly, none other than Professor G. Mohan Gopal, who is actually the force behind this organization. And again, we don't require any introduction, but still, for formality's sake, I would just say that he's a leading voice on judicial reform and justice in India, and he has been director of National Judicial Academy of the Supreme Court of India from 2006 till 2011. Professor Mohan Gopal heads the National Court Management System Committee of the Supreme Court, which is pioneered by him as a new national focal point for systemic improvement of the judicial system. And he's a former Vice Chancellor of National Law School of India, Bangalore, former member of various national regulatory bodies like Law Commission, SEBI, UGC, News Broadcasting Standards Authority, and he also has got a lot of international exposure. He has worked at World Bank in Washington for 2 decades, and he was the chief counsel in the legal department. And he was an adjunct professor at Georgetown University Law School, Washington, and also National University of Singapore. He has got a very extensive experience in this field, and he holds a doctoral degree in law from Harvard Law School, from where he obtained a master's degree in law as well. And welcome, sir, for the meeting.
Thank you, sir.
And next, that would be on the second session. The other panelist is Sunny M. Kapikada, who is well known not only in Kerala but also in India. He's a public intellectual, writer, and a philosopher. He has taken active part in various protests in Kerala for protecting the rights of Dalits, an influential orator who has been vocal about the marginalization of the downtrodden. And by profession, he is an LIC employee, and he has also written quite influential books in vernacular language in Malayalam, Kerala. Though he has not entered right now, probably he'll be joining soon. I welcome Sunny M. Kapikada for this session. And last but not the least, Dr. Binu Paul, who is currently head of the MBA department, Christ Deemed University, Lavasa, holds a PhD from the Department of Applied Economics, CUSAT, Cochin University of Science and Technology. His work focused on the income, livelihood, and education of tribal communities in Kerala. Worked as research associate at the Center for the Study of Social Exclusion and Inclusive Policy, CUSAT, where he worked on multiple research projects aimed at socio-economic aspects of marginalized sections in the society. So I welcome Dr. Binu Paul for the session, and we'll be waiting for your presentation in the second session. And I'll just tell you how we will be conducting this. We'll be conducting this meeting in 2 sessions, and the first session, that would be exclusively in English. Second session would be a combination of Malayalam and English. And in the first session, we would have Kanja Ilaya Shepard, Beswada Wilson, and Professor Mohan Gopal as the participants. And in the second session, we would have Sunny M. Kapikada and Binu Paul. So I think we'll just proceed with, you will get, each of the speakers will get 30 minutes time. So please confine within that time limit, because we have extended it further to start with. So confine your presentation within 30 minutes. Then after the session is over, we can have a discussion. We can have a question answer session, so that even public could ask questions, and all the members could answer. after the particular person has answered to that question. So I think we can proceed with right now. So we'll start the session with Professor Kanja Ilaya Shaput. Welcome, sir, for the presentation.
Thank you very much. At the outset, let me thank my friend Professor Mohan Gopal and also Vidyut for organizing this. Perhaps this is the first seminar, whether live or online, on the question of judiciary and the oppressed castes. I would use oppressed castes, Dalit Bahujans, because they are really oppressed in legal terms also. Now, the Indian judiciary, as of now, by and large is anti-Dalit, anti-Shudra, anti-Adivasi. It has a very nuanced relationship to religious minorities, because the religious minorities are global, whether it is Muslims or Christians. What happens to them is also heard at the global level. But what the judiciary does to Adivasi, the Dalits, and the
Vidyut,
backward classes and the Shudras in a larger sense, whether it is in the recruitment, whether it is in terms of evolving a judicial processes and relating it to the question of morality, ethics, democracy, justice. So there has been a consistent opposition to the productive communities' life and participation, development, liberation, wherever it was required. The reason, in my view, does not lie in constitution. Constitution is basically a legal system. But the reason lies in the large amount of judicial personnel who come from basically Dvija communities, who have a long-standing childhood training that the Dalit, Adivasi, Shudras are worthless people. Their culture, their need in the larger governance, participation in education, in employment, in overall development is not a divinely accepted notion. Now, this has gone into, by and large, the minds of large number of lawyers, right from the childhood and then in the training of the universities, and the lawyers become judges. So therefore, there is a set thinking that the productive communities have no abilities to engage with the national issues, the equality questions, and they should be in the production zone if they are cattle rearers, if they are tillers, if they are fishing, if they are, as Bezawada Wilson is dealing with, scavenging, or any productive work. But the Dvijas in India have never participated in production, and they think it is right. You must understand this because judiciary, whether it is lawyers or judges, are very religious people. If you see them around temples, festivals, the way they conduct themselves, they are very religious. There's nothing wrong in being religious. But they are religious in the sense of Varnadharma, in the sense of historical evolution of the Vedic law that they know, the epic law that they know. They consider them as laws. Vedic texts they consider as legal, epics they consider as legally valid, therefore they keep quoting from epics. I remember as a student of political science, we were taught the Shanti Parva as great political theory in Mahabharata. And then Kautilya and Manu are central to them in their understanding of law and state. Once they prioritize Vedic thought, Upanishadic thought, Kautilya and Manu, then the constitution becomes a secondary instrument of legal interpretation. Now, I've been reading a lot. I and Mohan Gopal for quite a long time have been interacting. Reading a lot about even the best of liberals, even the communist background lawyers, judges, demanding for constitutional morality, both from judges and lawyers. But the point is, all over the world, constitutional morality is a later evolutionary morality. Now, what is the primary morality is the spiritual morality of people, because most people are religious. And we know what happened in US. Trump appointed a judge which is spiritually conservative and pro-life at a time. And though these judges in US, Supreme Court judges, get grilled by the Senate, in India there is nothing like that. Judges appoint judges and lawyers become judges. Government intervenes in a way that it can and sees that its own people get. Now that is where we see some difference in the judges appointed during Congress period and where the communist parties were ruling and now when the BJP is ruling. So therefore my fundamental premise is, in all our schools and legal training colleges and institutions, spiritual morality is still Varnadharmic, and there are no large number of Dalit, Bahujan, Adivasi scholars emerging to contest that Varnadharmic morality as being interpreted as the right justice. Because the notion of justice has not come from straightaway constitutions. If anybody thinks that constitutional discourses, the first ever constitution written in the world was that of American Constitution based on the evolutionary legal thought of Europe, particularly John Locke and Thomas Paine and so on. Constitutional morality came from the spiritual morality. Now, I have a book in my hand. This is God's Justice. This is a massive book. It examines the whole notion of justice that emerged from the idea of God. Now, The central idea of God's justice evolved in Israel through a long period of discourse, and justice, the idea of nation, the idea of citizen, and the idea of notion of equality have roots in this God's justice concept, has evolved in. Now, in India, for example, in Hindu religion, there is no idea of God's justice. I have not read anything about the idea of God's justice. So, for example, the fundamental idea of God's justice starts with the assumption that God created all human beings equal. Now, I would like to know from Mohan Gopal, who has involved in training lawyers and judges and has been interacting with Supreme Court judges, several High Court judges. Do they think that Hindu God created all Hindus equal? Is there such idea among them? If the judges of Supreme Court, High Courts, the lawyers think that the Hindu God created all Hindus equal, then there is no place for caste. Then there is no place for untouchability. When the lawyer is arguing on behalf of the clients, if the client is a Dalit, if the client is Adivasi, and if the lawyers are not their own community lawyers, if they appoint a Brahmin, Banya, Kayastha, Khatri, or a Kshatriya, or even Shashi Tharoor kind of a Shudra lawyer, then I picked up Shashi Tharoor's name because he wrote a book called Why I Am a Hindu, without writing a word about caste, and justifies everything that is happening in the name of Hinduism. I picked his name not because I'm personally against him, because he's writing these days. So, if these people don't have the idea of God creating all human beings equal, then how do they deliver? How do they represent their clients? If you appoint a Brahmin lawyer to argue, then a Dalit, a Adivasi, an OBC, if we appoint lawyers to represent Brahmin, Banya, Kayastha, Khatris to argue reservation cases, what do they do? How do they present it? Then how do the judges listen it? See, in scholarship, there is what is known as the method of reading a text and understanding a text. How do you read a text and how do you understand it? In legal system, there is a method of arguing and there is a method of listening by judge. And the judges make those points and then deliver their judgments. Both in arguments and listening, if it is a varnadharmic, then what kind of judgment will come out? So my idea is you need to think of deep Brahmanized legal training. There is a book written by a friend of mine, Brajaranjan Mani, Debrahmanizing History. Is there any book written by any lawyer that de-varnadharmizing legal structure or de-Brahmanizing it? Is there anything like that? If there is nothing like that, what happens is, even if, I went to several law colleges, including the Bangalore National Law School, to give talks when Professor Mohan Gopal himself was the Vice Chancellor of that. 90% of the law students there were anti-reservationists without understanding, and very violently. They were not allowing me to speak. This is also true in the civil service. I spoke to very senior IAS, IPS officers. They said, no, we don't want to hear about anti-caste discourse. How can you counterpose Ambedkar to Gandhi? If you want to talk, you just praise both of them. Now, this is the kind of civil service, the legal student fraternity, and the faculty. I hardly found a Shudra, leave alone OBC, Dalit, Adivasi, top faculty member in national law schools, who has the courage and confidence to take on the reality of Indian social system and put, there is a village law. After all, what is law? What is judgment? What is judiciary? It deals with people's problems. Maybe a marriage, maybe a land dispute, maybe a murder, but these are resolved at village level in a much more with positive divine justice than what is happening in established courts of the Constitution. So to me, the constitutional morality argument is a very weak argument without foregrounding it on divine morality, on individual ethical morality. See, if law does not deal with individualism, then law naturally deals with groups as castes. So what Brahmins do will be right. For example, on the beef and vegetarianism issue. Beef was a very linked agenda issue now. Now, how do judges deal with beef question if all of them are pure vegetarian who think that meat food itself is pollution, which is taught in sociology, which is accepted in legal discourses? Now, see, I wrote this book called Buffalo Nationalism, and I asked two former Supreme Court judges in 2001 when we were taking the caste system to UN in Durban, Justice Verma and Justice Ranganath Misra, I think. They were saying that why should you take untouchability and caste to UN? We can resolve here. Now, then how are you comparing caste question to race question? I said, see, I was deposing before them. Now, in our constitution, there is a protection to cow. And mostly Indian cow is portrayed as white animal. Now, why there is no protection to buffalo? And buffalo is a black animal. Therefore, there is no protection, even though it gives the same milk and in more quantity. Then I asked Justice Verma, who was supposed to be a very progressive judge, that suppose if a buffalo was to walk into your Supreme Court when you were Chief Justice and demand equal right with cow, what would you have done? Perhaps you would have dismissed all the watch and ward staff there and asked them to wash the Supreme Court with milk. Now, if that is the attitude of, or that is the blindness of a Supreme Court about animals, animal equality, that too in the Constitution, it is natural that they will also look at this as caste inequality. It is from this point of view, I would say, every legal college must talk about God's justice, individualism, not collective casteism, and equality and morality. Constitutional morality is, to me, very inadequate morality because Constitution basically does not deal with moral questions. It deals with legal questions. Now, without a moral dimension to lawyer and judge, there is no question of they can go to Tirupati today and then give a lot of money there and then make more money in the courts by robbing Dalit, Adivasi, Shudra or women clients without any sense of guilt. So if the legal system is guilt, there is a saying, lawyer is one who tells lies, lawyer is one who sucks money, lawyer is one who by hook or crook manages a judgment in his favor without any morals. Now this morality comes from what I call God's justice, not human. If there is no fear of God also, there is no fear of anything. There is no fear of constitution, fear of law, because the castes are organized for themselves. If we are dealing with this kind of a massive system of 3,500 years, we need to undo this. So this is what the problem in my view. Thank you very much.
Thank you, sir. So it was a very good philosophical analysis. I'm not taking much time to reflect upon it. So I request Mr. Beswada Wilson to have his presentation. Thank you.
Thank you. And it is a kind of an opportunity to speak on the very crucial subject, and that too after Professor Kanchailaya, because he has already made the ground very clear. Actually, what are the causes for the injustice? So when you know that what are the cause for the injustice, so it is difficult for us to actually demand the justice, because injustice causes are very clearly in the part of the institution, whichever we are thinking about the Indian society today. So if you want to make any changes, we have to institutional changes. If it is not happening, it is a very difficult for us to think about the justice. So, for my opinion, how a kind of a untouchable or the very OBC or the tribal or the women or the marginalized groups or the minorities are seeing the courts. So, to be frank, the simple one word, they are all afraid of the court. If you say the court, there, see, the place where we get the justice about that, their opinion. God, if you go to court, our life is over, and the whole lifetime we have to run, and we can't understand the language of the court. The problem with the Indian society is majority the caste group, they were out of the language which was the ruling class language. It is a Sanskrit or something that other languages like. Now in the court also there is some language which is not less than the Sanskrit, which the ordinary person cannot understand at all. You enter into the court hall and there will be many people talking. Then another one more thing is, they also look like any temple. When they go, there is a priest, so you have to go through the priest to see the god light. So to seek the justice also here, through the advocate, through the judge, you will get the justice, what the constitution has actually promised. So constitution said very clearly, all are equal and you have a right to get the justice. And we have the natural justice, all social justice, many justice. And justice also different kind of a justice. It's not just one justice like, and there are many. So in these circumstances, first the ordinary people or the citizens majority, they get afraid of the court complexes. Second is about the judges. And the judges, the questions what they pose in each and every case, it is a very problematic, very problematic. We can't even explain. In some cases, in that and something, they're saying that how the dominant caste person will touch untouchable women, like as if that they're just entered into the court hall from the heaven or somewhere, and they can't understand the social reality and how the patriarchal society and what is the meaning of the rape, why the men is unnecessary entering into the rape, can't understand a small thing and put also into the. So what I want to make my point here very clear, if the judges has the caste mindset, so where is the point of expecting the justice? So they have the, before itself they come. And the unfortunately in the whole country, whoever we are, we have the a kind of a caste prejudice. We have to try to come out of that with the conscious mindset, that is with the constitution lens. So once we miss to look into the exactly the constitutional lens, so again the problem is definitely we will enter into the injustice practices it everywhere, and it happens and it continues. And if you look kind of a system also, within the system also you will not get any kind of a position here or there. So very simple, what I want to make one more point here is, also many times unable to understand the case which we filed in the Supreme Court in the 2003 to 2000, almost like a 14, it was there 11 years. They are unable to understand the difference between the toilet and the person who is cleaning the toilet. When we are arguing the case, or when the case is coming and they have to deal with the case, many times they just started asking about the toilet. They are not much concerned about the person who is cleaning the toilet and why they are cleaning, what made them to clean like this in the country. So what are the constitutional guarantees we can provide to them? By those lens, it is nowhere at all. So when the case comes, the judge's face goes very problematic way, which is a way I can't even explain here. They say, what has a time to think about the toilets? My lord, it is not about toilets, it is a matter about the people who 5,000 years like a slaves in this country, and they are unable to manage to get the justice in any courts or the any administrative measure. So they have reached to the court. So, but the judge asked again repeatedly, is the Supreme Court has the time to think about the toilets, how many are there in the country or not? So my if the judge is unable to distinguish between the difference toilet shit and the human being. So that itself is a big problem. The people who are coming are unable to get the justice anywhere, and they can't talk about the justice and what is the legal system and what is the judiciary. When they, after that, once our case is over, many are women scavengers, they are asking us, so they are coming to clear. They do know that the justice means all this point by point. They
Excuse me,
what the
excuse me,
officers who have
Mr.
not listened to us all these years, whether why they are not actually listening to these people. When who are there, not in the power, their voices nobody will hear. So actually is when the administration, total bureaucracy completely ignores certain communities, people, and certain issues, There actually they expect something may happen from the judiciary. But the problem here is judiciary also with the casteist mindset, with the prejudice, with the stigma, they started talking about the legal terms also in a very openly with the even the illiterates. So that is the major problem. We have no any kind of a legal education in a, we call in our with respect to the social issues. The people who are coming as an students, they are learning and the first as an exposure what is the manual scavenging. Why can't you put that into the syllabus in the anywhere? So the social issues is not the one community issue. All the social issues are the society issues. It is an pura samaj ka samasya hai. It is not an individual community or something. Untouchability is also not the problem of the untouchable. Untouchability is the problem of the whole society. Untouchables are the victims of the society's injustice practices. There, when you fight against the untouchability, which means you are seeking the justice that has to come from the all the other groups and the courts and everywhere. So here I want to make my point and I want to also close. So when we look into that Manu statue in front of the court, so what else you will expect? So these are the symbols so openly now in the society. We started celebrating and we come very openly all these things. Not eating something. So they will say that all these 9 days, all others also should not eat. So for that, even the judges also supporting, judges also going, and you go for the enemy. So there is a public interest litigation, which they completely now not taking for the sake of the actually for the public interest. That is a completely they stopped. Then second is suo moto. No judge is taking suo moto off the issues which are very, very problematic issues like because they think that if I argue these cases, if I give some kind of a remarks on this, I will not get the better future after my retirement. Most of the judgments in the country are based on the after the retirement what they are going to get. If the judges are in this that kind of a status, so how the marginalized will get the justice? So even if the untouchability and all these practices, it is a, if you think about the just why it is as a concept. So they think that they not believing the equality. If such people sitting on the mostly in the judiciary is a very very problem for the whole country because you don't believe the equality which is an actually constitution says. So that is a and before closing I want to say one more important thing also. Social justice we always say social justice is not talking about only for the section of the Dalits arena. Social justice as a society is to transform to actually to lead a constitutional framework of the life. So we have no respect on the constitution even now. So that is a major. So Baba Sahib Ambedkar, the true words what he has spoke in the constitution that we have to go through that now. We have to again reframe most of the things. And here that I also mentioned in the beginning that priest and the God that between what how it is happening live. So there are certain castes they born like this, they can rule like this. So that is not wrong. That is already a notion is there. So unless you break that caste prejudice from the mind, it is difficult to pass any kind of a order. The passing order is not just automatically it comes. It comes by the virtue what the you believe, strong belief system what you have. So majority unfortunately coming from the dominant class, unfortunately coming from the male, unfortunately coming from the different class group. So they also always look or the protect interest of that particular section. And second is they are fail to understand sensibly the issues of the marginalized. The marginalized issues, the power, hunger. So we don't talk about the hunger. So how big is the issue of the hunger in this country? It is not a small. How we have reached to the the number of the 94. So we are in the 94 in the hunger index in the country, in the world list. So how we reach? At the same time, we have the almost like 76.74 million tons of the food grains are there. So why we don't talk about it? Because this is the food or the hunger. These are the issues of the Dalits, Adivasis, OBCs, marginalized. It is not the issue of somebody else. So we don't talk about that at all. So my point is, if we are unable to understand even the hunger, which every human being will be having that experience every day, at least 1 or 2 times. You do experience without the food, how difficult, but you don't pass even a single order about the hunger. So many, I want to make, one is a hunger, second is unemployment and untouchability, patriarchal values, and how we pass the orders, and in many commissioners, and how they pass the orders. इसका खिलाफ against that, no judge is taking any suo motu. So what I want to close before saying that marginalized people are in opinion that the court of justice are not going to provide any justice for us, and it is a justice for the dominant caste people only, and they will only get the justice in their courts, and these courts are making only suppressing and wasting our time, and even if you go to the court, they will be making us fraternity always we say. So liberty is fraternity world, but we have the caste fraternities, fraternity legal committee, so they have their own fraternity. The caste fraternities too, we have to reach to the a kind of a human would, how we are going to establish, so thereby we can really see that the justice is flowing like a water to the actually the marginalized. Thank you.
Okay, thank you, Mr. Wilson Biswada. It was of the experiences from, particularly from Manuel Scamage's livelihood and life experiences, and also you have suggested certain solutions for it as well. So thank you for that presentation. So now next we are moving on to Mohan Gobal sir. But before that, let me tell you, Dr. Mohan Gobal sir, that please kindly switch off all the members other than the speakers, so that we can reduce that noises in between coming in.
Yes. 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 I've done that. Yes. So thank you very much, Professor Vidyut, and thank you very much, Professor Kancha and Wilson ji, for excellent interventions. Professor Kancha has taken us to the issue of the spiritual morality of the idea of justice, and to remind us that we have to have a deep foundation of the idea before we can hope to have a system that delivers justice. And Professor Kanta also raised questions of training and institutional issues, which are very, very important, and I will address some of them now in my remarks. And Mr. Wilson Bezwada, as he always does, took us straight into the hearts and the pain and suffering of people, and basically told us that there is no balm, no relief, no solace coming from these courts. And I was reminded of an encounter that I had with a landless Dalit about 150 kilometers away from Bhopal when I was living in Madhya Pradesh, whose home and family had been viciously and violently attacked by dominant caste members, in order to acquire their land for their own purposes. And when I went there, and I found that I heard about this, it didn't come in the press, someone mentioned to me, so I just went there in capacity. And when I went there, I found that the court complex was only 1 kilometer away from this village where this had happened. And someone I knew through the Judicial Academy was then the principal district judge, and I knew that he was a sensitive judge, very well-trained judge, very highly educated judge, very committed judge, very honest judge. And so without saying any of this to these people, I told them, why don't you go to the court that is 1 kilometer away and lodge a complaint about what's happened to you, and I'm sure the court will protect you, because that's their responsibility. So he looked at me, recognizing that I am a fool who knows nothing about the real world, and speaking very slowly, as you speak to people who may not understand quickly what you're saying. He said to me, a court is a place where the police forcibly takes you to. No one goes to a court. So this became a new definition of courts, because coming as I do from the legal profession, if you ask any of us, most of us will say, if I ask any of us what is a court, we would say a court is a place of justice where rights are secured and people go to protect their rights. But here was a landless Dalit educating me about the people's definition of a court as a place where you are forcibly taken by the police to be punished, and a place that no one will voluntarily go to. So I have, over the years, shared this with literally thousands of judges and law students across the country. And I've asked them, when will this definition change? And a landless Dalit will say, yes, I've already been to court, because a court exists to protect me. And I would go to court as I would go to a good hospital if my bones are broken. I would go to a court if my rights are broken. How and why? And clearly, that episode enough is enough to answer the question: are courts delivering justice for the caste marginalized? Apparently, as no, they're not. But we have to ask ourselves: how do we understand this problem? How do we frame it? And what are the different indicators or matrices by which we can answer this question and seek a solution? So first of all, I'd like to begin by saying that we should understand that we are in a moment of change, a process of change. We can either look at the system as non-functional and failing, which it is, or we can understand that the legal system and the judicial system is a very ancient system, starting from ancient times through the feudal rule of Maharajas and then Mughals, and then coming to colonial times. Very quickly summarizing this period. In fact, I generally, from a legal point of view, structure it into the Raja era, the Raj era, and the Swaraj era. Unfortunately for us in the constitution, these courts continued from the Raj era from the Raja era to the Raj era to the Swaraj era with almost no structural constitutional change. The only new court is the Supreme Court of India. So when we look at the change, I was reading the other day a 1957 article by Professor M.N. Srinivas, who, as we all know, is a right-wing sociologist, quite casteist himself, one of the founders and fathers of the discipline of sociology in our country. So this is from that point of view, a very, very conservative source. I'm going to read 3 or 4 lines from that article about the legal system. Professor Srinivas says, it is widely held that the civil and penal codes introduced by the British over the subcontinent of India took away much power previously exercised by caste panchayats. The British also introduced a new principle of justice, namely that all men are equal before the law, and the nature of a wrong is affected by the caste of the person who is committing it, or by the caste of the person against whom it is committed. It is necessary to emphasize in this connection that the use of law courts by some peasants did not put an end to caste panchayats. The peasants made use of both systems of justice. Traditional panchayats, caste as well as village, this is in 57, not very different now in some parts of North India, are still functioning in many parts of the country. This fact is in all schemes for the revitalization of panchayats and so on. Now, what I want to say, I've ended the quote, is that we must understand that the Constitution of India after independence started a process of completely changing the role of courts, principles of justice, in a very revolutionary manner, in a manner that would from protecting the powerful against the powerless to protecting the powerless against the powerful. But it was not until, I believe, 1964 that we had for the first time a Chief Justice of India who had not been appointed by the British as a judge when they were colonial rulers. And they still, these colonial traditions, using the words lordship, using the words, pleads, using the word petitions, rather than complaints or remedies. These kind of traditions where the people are are pleading before the majesty of the law is still continued in our country. So we are now in a transition where we have, as Professor says, referring to the peasants of the system, he refers to 2 systems of justice in the country. One, a feudal system, and the other, a constitutional system, in reality, not in formal legal terms, but within those legal structures, in those buildings, actually 2 systems of justice are struggling against each other. One I would call Savarna justice, and the other I would call Swaraj justice, based on the Constitution of India. And when I say Swaraj, I mean individual freedom, liberty, equality, fraternity, the values of the Constitution. And it is in this struggle, in this context, that we must see that that there is no justice, as both Professor Kancha Ilaya and Mr. Wilson Bezwara said, for the caste oppressed or the caste marginalized in our country. I should just go back to that story that I related from Madhya Pradesh, because when these people, these landless Dalits saw that I was very disheartened when they refused my suggestion, they rejected my suggestion that they should go to court. They took pity on me and they said, we'll find a solution for you. So they said, look, they asked one of them, bring a piece of paper and a pen. So someone brought a piece of paper and a pen, and they told me, please write a letter in the the strongest English you can to that judge you talked about, and give it to us. We will take it to the police guards in front of the courts. We will give it to them and say, this is a letter for the judge, and we want you to write it in very hard English, because we do not want the policeman to be able to read the letter, because then he will may not take it to the judge. So he should not understand the letter. It must be to the judge, and then hopefully he will take it to the judge. Judge will see it. It's from you, and if he is really a nice man, like you say he is, then he will call us. So let's try that. So I said, fine. I wrote a very toughly worded letter, notwithstanding, hitherto, without reference to, with respect to all those technicalities. And I gave the letter to this judge who I knew, but I did not tell them I knew him. And then I said goodbye and I left. A couple of days later, I called them and I said, what happened? They said, we took it to the policeman. He tore up the letter without even reading it and threw it into the on the road and said, what do you people think? You're going to see the judge and you're going to give a letter to the judge? Get lost before I beat you up. So he said, this is what actually happened. So you can see that these institutions are still, as both Professor Kancha Elaya and Mr. Wilson Bezwada said, very distant and very inaccessible to the oppressed castes. They have to encounter caste prejudice at every level. When we say courts and judiciary, we have to mean, and we do mean, all elements of the system, not just the judge, but the lawyers, the staff, the officials, other officials of the court, related to the court, the whole industry that works around the court, making money and a living out of protecting justice. So this system is still hardly changed, and to a large extent, I have found in my experience working across the country that these courts are a mirror to society. So courts in Kerala are the least inhospitable to the caste oppressed, more accessible to the caste oppressed, because Kerala as a society has evolved more on the path to democracy than courts in Madhya Pradesh or in Bihar and so on, where they're still extremely feudal. So therefore, we must understand that, as Srinivas himself says, conservative man, that we are in a situation where two systems of justice, Savarna and Swaraj justice or constitutional justice, are clashing with each other. In this context, I feel that we have to look at 3 or 4 aspects of the judicial system as important matrices or indicators to understand its attitude to the caste oppressed. One is what Mr. Wilson Bezwada raised, which is what value does it give to the suffering of the caste oppressed and the poor? What value does it give to manual scavenging, to violence against the poor, caste violence against the poor? We recently had a discussion on Hathras, where I was making the point that the brutal, inhuman rape and murder of the young girl and the brutal and inhuman destruction of her physical remains after her death are really part of the old traditional Savarna idea of justice, where raping Dalit women was part of their tradition. And in fact, those women were expected to be handed up to them to be raped. And now that the constitution has come, has made it a little more difficult for them, they are reacting by increasing violence. Untouchability has morphed into atrocities, as in other countries like racism. The Civil Rights Act increased physical attacks against the African Americans, and a whole series of attacks, which still continues, racist attacks, because the stronger the protection of the law and the greater the opportunities for the race oppressed or caste oppressed to protect their rights, the greater the backlash. In fact, in this article, as many of you may have read it, Srinivas' central argument is that actually the introduction of greater rights for the caste oppressed has increased casteism in India because of the backlash of protection of the rights of the caste oppressed, almost making an argument that maybe it was not a good idea to do it, which of course I would strongly disagree with. So we have to look in specifically at not only the as I said, the question, what value does the system give to the most urgent, most burning concerns of injustice of the poorest in the country, and the answer, as we know, is very little. So you have Ambani's brothers dispute being directly resolved by the Supreme Court with high level of priority. That kind of priority usually only when poor people have to be given the death sentence, then the courts meet and ensure that the time schedule is maintained and revenge is exacted from those convicted, who generally happen to be very poor people. So I think this is at the heart of our democratic change, and this takes us to Professor Kancha Elaya's point. How do we what is our sense of morality? Morality is a system of attributing value also of what is important and what is not important, and what is of greater value and what is of less value. So an assault on the humanity of a human being, merely because that person is a human being, regardless of the caste of that person, should be of very high value. And the absence of that value, Professor Kancha would tell us, is an indicator that we do not have an appropriate and strong sense of spiritual morality underlying the judicial system, which is why it does not value the suffering of the oppressed. Going beyond that, I would say that specific, and I'll finish in now, because we are almost at 6:30, and I wanted to end the session on time because some people will be joining for the next session. But we'll have another follow-up on the more technical aspects of this question, looking at it from the internal justice point of view on a future date. But if I were to look at the main provisions made by the Constitution in favor of the caste oppressed, which are, according to Srinivasa, provoking the upper caste into backlash of violence against the caste system, and that is not being defended by the courts, because they don't believe that there is any injustice when the old morality, the Savarna morality, is applied in society. These are, let's say, one person, one vote, universal adult franchise, and the very valuable vote, equal vote that was given to every person in this country, regardless of caste, regardless of wealth, or regardless of region or background. Unfortunately, in these many years, the judiciary has not given its due importance to the right to stand for elections, and the jurisprudence says actually that we do not have a fundamental right to vote, which I think is wrong. The same standard has been applied to reservations. There have been many interventions, including putting a 50% cap on reservations, which Justice Chinnappa Reddy, in his biography, in his autobiography, or a book on the Supreme Court on the Constitution, called "The Constitution, Its Summits and the Court and the Constitution, Summits and Shallows," Justice Reddy says that this 50% limit on reservations is unconstitutional, and so the judiciary has gone outside the Constitution to limit reservations, to bring in a creamy layer, to dilute the provisions as envisaged in the Constitution, which in turn has had a slowdown effect on the very powerful tool that the Constitution has put into our republic, into its administrative structure, namely reservations. Another very important area where we can see what the judiciary has done, played a very important role, is in the area of religion and law. There is a 1922, I believe, Privy Council judgment, four-judge bench judgment, in which the Privy Council looks at the Hindu law on creating endowments and creating mutts, and these temples and these religious institutions by encouraging and protecting the donations made by rich people to these temples. They look at that whole structure. The judgment, which was by Justice Amir Ali, who was the first Indian judge to be a Privy Council judge, he writes there very clearly in the Privy Council judgment that the purpose of this institutional framework in law to support Hindu religious institutions is to advance the mission of bringing the native Dravidian population under the Aryan religion. So we can see that the judiciary has consciously protected the framework for bringing the oppressed communities who are not part of the Indo-Aryan Brahminical tradition under the control of the Indo-Aryan Brahminical tradition, and thereby actually taken a line which is inimical in terms of practical theory and practice and theory towards the interests of the caste oppressed. The number of judgments of the Supreme Court have given priority to organized religion and particularly to priestly religion, and has not given the protection of Article 25 right to religion to small belief system typical of the oppressed castes, of the marginalized castes. And so there has been a strong bias towards organized religion, priestly religion, and within the Hindu religion, Brahminical religion in many of the judgments over many years of the Supreme Court. So whether it is in terms of voting, whether it is in terms of reservations, whether it is in terms of facilitating a program of proselytization and conversion of oppressed caste Hindus into the Indo-Aryan or other Brahminical or other religious systems, and whether it has been in terms of upholding the social welfare system and ideal justice. In all these areas, I think the jurisprudence that has been developed is very much against the interests of the caste oppressed. Lastly, I would say in terms of the internal culture of the courts, there is need for, as both the earlier distinguished speakers pointed out, there is need for a fundamental cultural change, and that can only come when the judiciary becomes more representative of all the people in the country. Today in the Supreme Court, there is only one scheduled caste judge, there is no scheduled tribe judge, and there is, to my knowledge, there is no Avarna OBC in the Supreme Court. So whereas, in fact, these judges from these backgrounds should have been the vast majority of the judges of the Supreme Court. We are going into the 8th decade of our independence, and we are the voices of the vast majority of the people of this country, and their ideas of justice and their concepts of justice are not represented. In conclusion, I would say that as against the emphasis of Savarna ideas of justice and colonial ideas of justice on order over law, over justice, order must prevail, which means the existing system must be continued. As against that idea, I have always maintained and discussed with several of you that the Adi or Avarna idea of justice is located primarily in relief for suffering, relief for injustice, based on compassion and based on friendship and fraternity and kindness, and protection of not only human beings but all of nature, because these ideas of justice recognize the strong interdependence between human beings and the rest of nature. So we have also got to rethink the ideas of justice that we have inherited from feudal colonial times, and we need to ensure that the ideas of justice of the common people of this country find its due place as the guiding idea of justice of the courts of India. So from access to ideas of justice for a whole variety of reasons, I think there can be little argument that the courts of India are still not able to deliver justice to the marginalized castes. And the struggle between, as Mr. Srinivas said, between two systems of justice, one of the privileged dominant caste, and the other, the constitution as the voice and of the common people of the country. That struggle still continues, and we will have more opportunity to discuss a program of action to take this forward. And I would like to thank again the panelists for being here, and thank you, Mr. Vidyut, for giving me this opportunity.
Thank you, Professor Mohan Gopal. It was a really wonderful presentation. So I think we'll just move on to the question and answer session, right, sir?
Yes.
Okay.
Yes.
So, but before that, I'll just conclude. I think
Yes.
the first session is by now over. So a question answer session would follow. But I'll just say that upon reflections of the three presentations, what we could see is that the presenters have identified three things, particularly when you look at uh, the judgments of the Supreme Court, that there is a non-understanding of constitutional justice or constitutional morality, which can be seen in few of the judgments pronounced by the courts. One. Second is that there is also an existence of an idea of Savarna religious justice or Savarna morality, which is existing, that is being reflected in the judgments. And also the idea of individuality, the liberty and the dignity of the individual has not been taken into account in its proper sense, and more significance is attributed to the group or caste part within the society that is reflected in the judgments. And moreover, a particular caste is being, or that caste system is being given significance. This is reflected from Professor Kanja Ilaya's presentation. And whereas moving on, Wilson Beswada has identified a few problems which is existing in the group of manual scavengers. And the most important is the language problem. So they use vernacular language, and the English as the medium of court language has created significant problem for access to justice. And there is also non-understanding of law being technical, and also there is lack of knowledge due to non-inclusion in schools of all these values which we are talking about. Then again, he was referring to the problem of hunger and the lack of knowledge of constitutional justice as well. So certain experiences has been identified. And when moving on to the presentation of Mohan Gopal sir, he has is very expressive of ideas through his own terminologies. Like he was identifying two systems of justice, like Savarna system and Swaraj system. And according to him, what is predominant in Indian cultural context is the Savarna system, and that is being reflected in the increased violence from caste oppressors and non-understanding of what values has to be adopted for addressing the caste marginalized communities. Though we have a constitutional scheme of protection for the caste marginalized. And he also identified a number of judgments reflecting Brahmanical ideology-oriented jurisprudence. So this is the gist of the presentation. So we'll be reflecting upon it in the coming sessions as well. So I think we'll move on for, sir. We'll move on for the question answer session. And I request Gopal sir to switch off the mics of whoever is not speaking.
Yes. Yes.
So the forum is open for questions.
May I have the very senior advocate, Mr. V.K. Biran, and so Mr. Haji Abdullah Kuti are here, and if they would like to comment or ask any question, we would be very happy. If I may suggest, Mr. Vidyut.
Yes, definitely, sir.
Sir, Professor Mohan Gopal's speech was very exactly. It was really a lesson for us, because he marshaled every step of this development of judicial system, and ultimately he described the Justice Amir Ali's judgments and views with regard to the suppression of Dalits and Adivasis and other marginalized class. Thank you, sir, very much.
Thank you, sir. Abdullah Kuti, Haji Abdullah Kuti would like to say.
Sir, unfortunately, I joined late, so I couldn't grasp more. But I am very much impressed from the conclusions referred by the commentator here. And since Biran Sahib has expressed some remarks, I have nothing to add at this point.
Thank you, sir. And we will have we have another opportunity later. Now, Dr. Sunny Kapikad may have any comments that they would wish to address to Mr. Wilson Bijwada or Professor Kanchalaya before they.
No, I don't have any comments. I think it was very impressive with the kind of overview that they gave. But I have nothing to add. I'm really impressed with the coverage of the issues that the people face.
Sir, actually, Sannyam Kapikad has not got connected. So I request you to just call him so that I have tried, but in fact, he's not picking up. I do not know whether there is any, since he's in the hospital.
Some problem. Yes. I will call him.
Tried more than 5 times, but he's not picking up. So I do not know whether any questions from anyone.
So thank you, sir. I say thank you, sir.
Oh.
I would like to request Mr. Wilson ji and Kancha ji to give us some any concluding thoughts with you before we move to the next session.
Sir, just I want to make one point which Professor Mohan Gopal has mentioned about the caste panchayat which we
Namaskaram.
Hello, can you hear me?
Yes, sir. We can hear. You can proceed with.
Yeah, caste panchayats are we call that as a katta panchayat or something in the South India. See, the Dalits are not better kind of a justice than the caste panchayat even in the judiciary system. When the caste panchayat, where they know very clear, the dominant people, the rich, the whoever is there in the village, they will be always making allegations against the Dalits and the poor and the women. And everybody will believe that the Dalits will definitely, they will rob, they will steal or something. And even the Katta Panchayat or the Caste Panchayat, nobody will think, will not. How can we suspect lie? The same mindset is now reached to the judiciary also. Judiciary also thinking that Dalits means they will be like this, one understanding. So that we are, unfortunately, we are not breaking. And at the level of the village, definitely the untouchables, the Adivasis and the OBCs, they don't get the justice at all. So they used to always expect to go to the up to the collector, district level at least. So where there will be some sensible people. That it becomes like other. Now there is no justice anywhere. So the Hathras case also. So, state buried in the night and nobody is asking why. So there are the many things to discuss like this, but we have to really understand we have not enhanced our justice system from the caste panchayat to equal justice system act.
Correct.
Thank you, sir. So, Professor Kancha Ilaya, any concluding remarks from your side, please? Your microphone is muted, sir. Please unmute your microphone.
Okay. Yeah.
Yes. Okay.
Is it
Thank you.
okay? See, what we heard in this session is that there is a deep caste problem in the judiciary, both at the higher level and medium level, down at the municipal level. I think at the municipal levels, there is some justice happening because of state government appointments, reservations, and Shudra existence, and the Dvija existence along with them as a balancing factor. As you move upwards, high courts and Supreme Court, the Brahminical order gets more and more strengthened, and it is religiously very systematically trained. It is family influence, institutional influence. So maybe we'll have to look for two strategies. One, the immediate problems that we are thinking, like, what Bejawada is saying, and how to get justice in this issue, that issue, is one dimension. But I think the problem is not going to be solved there. A massive number of youth must be from Dalit, Adivasi, and backward, and also even the Shudra, conscious Shudra. Justice Chennap Reddy is a Reddy. Jeevan Reddy was a Reddy. Sudarshan Reddy was a Reddy. They all were more sensible in many ways. So occasionally there could be a judge like Krishna Iyer, who coming from the Brahminic background with some sense of people's rights, but that is weakening more and more. So my view is that, see, the language question, we should not give away English to them. It cannot be removed. Therefore, the only option is all our children from tribal areas to villages to universities have to be brought into English medium. So massive movements need to be started for English medium education in government schools. We have seen in this area that judges, lawyers, judicial persons who put their children in high-class English medium were opposing English medium to government educated rural poor. So there is a diabolism problem here, there is hypocrisy problem here, there is a skillful management of their hegemony continuing there. Therefore, English has to be Indianized and completely declassized and made accessible to everyone. That Madhya Pradesh man is right. If you speak to constable in English, he will not stop you on the road. If you speak to him in Malayalam, Telugu, Tamil, he will stop. So that's how the ruling educated English class get anything that they want. Therefore, English has to be massized now. That is only the way. And the syllabus structure in the law colleges must be carefully looked at. A lot of writing has to go on that. We should evolve syllabus, suggest what kind of, for example, this whole question of God's justice, God creating all human beings equal, God never creating caste, dignity of labor issue. Okay, whether it is toilet cleaning in this worst form or flushing or technology growing, my understanding is unless the mass Dalit Bahujan Adivasi masses come into modern higher education, our technology also won't grow. We'll have to depend on West. And tomorrow we'll have to depend on China. Therefore, we'll have to, lot of people need to work on writing text, that too in English. The regional language centrality does not work. I think a lot of things need to be done, both the levels. Every day, seeking solutions to everyday problems as of now, but training the Adivasi, Dalit, OBC, and the Shudra, even conscious Shudra forces into the judicial process in a big way with a philosophy of our own. Unless we have an alternative philosophy, we can't do that. See, the cow nationalism can be countered only with buffalo nationalism. There is no other way. Therefore, you all have to think in those terms, and biomedia solutions are not there. Thank you.
Thank you so much, Professor Kancha. Wilson ji is traveling and his battery died, so he had to get off. But I think we have a very rich set of materials, and I think we have identified, as Professor Kancha has said, a very huge issue for, in terms of the extreme gulf between the reality of caste and the recognition of it by the legal system. Whereas Article 39A of the Constitution, the state shall ensure that the operation of the legal system shall ensure justice on the basis of on the basis of equal opportunity. And so we are, does that justice include caste justice? And is caste justice, how do we frame caste justice? And we as legal academics, one of the big problems is that we as legal academics have not put the issue of caste into the study of law or the research of law. And all lawyers and all future justices are in the legal academy. And so the bar and the bench are naturally not sensitized during their education to look at this issue. I remember 20 years ago when I was at the National Law School, Professor Kancha came and made many lectures which were very effective in communicating to the students about these issues. But those were isolated lectures. I started a center at the National Law School called Caste, Communalism and the Law, and it was later merged into a social exclusion or some center which was started, you were also involved with that, by the UGC, whereas I created that center because I thought that center could become a basis for systematically looking at issues of casteism and casteism, communalism and the law, because I believe that communalism arises because the dominant castes want to divert the attention of the lower of the oppressed castes away from their plight and the responsibility of the dominant caste towards a minority as responsible for their plight. And so that's why there is a link between casteism and communalism, as we all know. So we have that center did not survive; it was closed down. There is no other. That was the first, and to my knowledge, the last center that by name was focused on the issue of casteism in legal education. So we need to work together to do more research on this, produce more data, more evidence, more writing, and bring this into the legal education agenda, and then into the judicial education agenda, into the bar, continuous legal training, and we would then start to see some change. In addition to, I totally agree in strengthening and deepening reservations within the judiciary and in all segments of the legal and judicial system, including in legal education, so that the legal system becomes representative of the people of the country. We must also, from the point of view of the legal system, seek to identify better answer better the question, what is caste, and how do we deal with it? Why should we deal with it separately from a legal point of view? And what is our approach to understanding and resolving this problem? So I think we've made a very good beginning, sir, Professor Kancha, for what I think is a very important. We'll write this up over the next few days, the main points that we discussed, and then send it to you as a draft. And after getting input from you, in our name, not implicating anyone, we will circulate the results of this discussion to some of the judges and legal academics so that they will become aware of this. So you're back now online, Vidyut?
Yes, sir. Okay.
And yes.
Okay, thank you.
So thank you so much for that wonderful discussion we had. Thank you, Professor Kancha Ilaiah, and thank you, Wilson Beswada, and thank you, Mohan Gopal sir, for the wonderful session. And now we will move on to the second session, in which we have Sunny M. Kapikada and we have Dr. Binu Paul. I think we'll switch on to Malayalam as well, right, sir?
Yes, because Mr. Kapikad, he speaks in English and in Hindi, but in Malayalam, but he prefers to speak today in. We're very grateful to him, sir, Mr. Sunny Kapikad, for joining us in the middle of a family emergency. His mother was not well, and he's actually speaking from the hospital. And thanks to Mr. Wilson Bezwada, who is traveling in Bihar from Ara to Buxar. And he was also speaking from the wayside and now back in the car. So people have, they've all gone, and Professor Kancha has very generously spared his time. So thank you to all of them for their presence here. Now over to you, Professor Vidyut, for your, of course, keenly awaiting.
Thank you, sir. Thank you, Mohan Gopal, sir. Sunny M. Kapikad, sir, Kelkamo, can you hear me? Sunny, sir, mic unmute yamo. Muted on microphone. Unmute yamo.
Even unmute ചെയ്യാൻ. Okay. Yeah.
Sir, Sunny M. Kapikad, sir, Kelkamo.
Hello.
Yes. Sir, Kekamo. Hello? Can you hear me? Kekamo.
Kelkam.
Okay. So I'll just. My dear friends, now to Malayalam, and the second one in Malayalam, and this presentation will be in English. Sunny M. Kapikad sir would be talking to us in Malayalam, and Dr. Binu Paul will be talking to us in English. Malayalam introduction for those who are watching in the Malayalam. അപ്പോൾ നമ്മുടെ ഈ സെഷന്റെ ടോപ്പിക് എന്ന് പറയുന്നത് കോടതികൾ നീതി നിർവഹിക്കുന്നുണ്ടോ എന്നുള്ളത് ഒരു കീഴാള കാഴ്ചപ്പാടിലൂടെ, അല്ലെങ്കിൽ കീഴാളർ എന്ന് പറയരുത്, ഒരു അവർണ അല്ലെങ്കിൽ വർണ്ണ വ്യവസ്ഥയ്ക്കകത്ത് നിൽക്കുന്നവരുടെ അല്ലാത്ത കാസ്റ്റ് മാർജിനലൈസ്ഡ് അല്ലെങ്കിൽ ജാതി കൊണ്ട് പാർശ്വവൽക്കരിക്കപ്പെട്ട ഒരു വിഭാഗത്തിന്റെ കാഴ്ചപ്പാടിലൂടെ കോടതികൾ നീതി നിർവഹിക്കുന്നുണ്ടോ എന്നുള്ളത് മനസ്സിലാക്കുക എന്നുള്ളതാണ്. അതിനെക്കുറിച്ചുള്ള അനുഭവങ്ങൾ പങ്കുവെക്കുക എന്നുള്ളതാണ്. അപ്പോൾ ഇന്ന് നമുക്ക് സെക്കൻഡ് സെഷനിൽ ആദ്യമായിട്ട് കേരളത്തിലെ പ്രശസ്തനായ പ്രഭാഷകൻ, ചിന്തകൻ, എഴുത്തുകാരൻ ആയ സണ്ണി എം കപ്പിക്കാട് സാർ നമ്മളോടൊപ്പം ഉണ്ട്. ഞാൻ നേരത്തെ ഒരു ഇൻട്രൊഡക്ഷൻ തന്നിരുന്നു. അപ്പോൾ ഇനി സമയം കളയാതെ നേരിട്ട് അദ്ദേഹത്തിനെ ചർച്ചയ്ക്ക് ക്ഷണിക്കുന്നു. വെൽക്കം സർ. മോഹൻ ഗോപാൽ സാർ, അതിന് ഒരു മിനിറ്റ് മുമ്പ് മോഹൻ ഗോപാൽ സാർ മൈക്ക് എല്ലാവരുടെയും ഒന്ന് സ്വിച്ച് ഓഫ് ചെയ്യണം, സാറിന്റെ ഉൾപ്പെടെ. യു ക്യാൻ പ്രൊസീഡ്. തുടങ്ങാം.
എല്ലാവർക്കും എൻ്റെ ജയ് ഭീം. എല്ലാവർക്കും എൻ്റെ ജയ് ഭീം. നീതിയെ സംബന്ധിച്ച ഏറ്റവും കീഴ്ത്തട്ട് ജനത ഫോളോ ചെയ്യുന്ന ഒരു സങ്കല്പനം എന്താണ്? നീതി എന്നത് തന്നെ ഇന്ത്യൻ സമൂഹത്തിനകത്ത് ഈ സിസ്റ്റങ്ങൾക്കകത്ത്, കോടതി ഉൾപ്പെടെയുള്ള സിസ്റ്റങ്ങൾക്കകത്ത് പ്രവർത്തിച്ചു കൊണ്ടിരിക്കുന്നത് എങ്ങനെയാണ് എന്ന വിഷയമാണ് ഇവിടെ ചർച്ച ചെയ്തുകൊണ്ടിരിക്കുന്നത്. ചില സാങ്കേതിക കാരണങ്ങളാൽ എനിക്ക് ആ ചർച്ച ഒന്നിൽ പോലും പങ്കെടുക്കാൻ കഴിഞ്ഞില്ല. അതിൽ വലിയ നിരാശ ഉണ്ട് എന്ന് ഞാൻ അറിയിക്കട്ടെ. 2-3 കാര്യങ്ങളാണ് ഇതുമായി ബന്ധപ്പെട്ട് പറയുവാനുള്ളത്. ഒന്ന്, നീതിയെ പൊതുവിൽ മനസ്സിലാക്കപ്പെടുന്ന ഒരു കാര്യം, നമ്മുടെ മുന്നിൽ ഉണ്ടാവുന്ന ഒരു ഇവന്റ്, ഒരു സംഭവത്തെ ഒരുപക്ഷെ മുൻവിധികളില്ലാതെയും ഏകപക്ഷീയമായും സ്വീകരിക്കുന്നതിനപ്പുറം ഒരു ജസ്റ്റ് പൊസിഷനിൽ, ഒരു ഫെയർ പൊസിഷനിൽ, പ്രത്യേകിച്ച് ആ സംഭവത്തിൽ ഉൾപ്പെട്ടവരോട് പ്രത്യേക മമതയൊന്നുമില്ലാതെ ഒരു തത്വത്തിന്റെ അടിസ്ഥാനത്തിൽ, എല്ലാവരും തുല്യരാണ് എന്ന ഒരു തത്വത്തിന്റെ അടിസ്ഥാനത്തിൽ പെരുമാറുന്നതിനെയാണ് നീതിപൂർവകമായ പെരുമാറ്റം എന്ന് നമ്മൾ വിളിക്കുന്നത്. അപ്പോഴും അത് കേവലം നിഷ്പക്ഷമായ ഒരു കാര്യമായിരിക്കുന്നില്ല. മറിച്ച് ചില തത്വങ്ങളുടെ, നമുക്കെല്ലാവർക്കും തുല്യതയും തുല്യ അവസരവും തുല്യ മാന്യതയും ഉറപ്പുവരുത്തുന്ന ഒരു തത്വത്തിന്റെ അടിസ്ഥാനത്തിൽ ചിന്തിക്കുന്ന ഒരു സമൂഹത്തിന് മാത്രമേ നീതിപൂർവകമായ ഒരു പെരുമാറ്റത്തെ മുന്നോട്ട് കൊണ്ടുപോകുവാനാകൂ. ഇത് ലോകത്തിലെ തത്വചിന്തകർ, ലോകത്തിലെ രാഷ്ട്രീയ ചിന്തകർ പല രൂപങ്ങളിൽ പറഞ്ഞിട്ടുള്ളൊരു കാര്യമാണ്. ഇതല്ലാതെ എനിക്ക് പ്രത്യേക ഒരു നീതിയോ വേറൊരാൾക്ക് മറ്റൊരു നീതിയോ സാധ്യമല്ല. മറിച്ച് നമുക്കെല്ലാവർക്കും ഒരുമിച്ച് ഫോളോ ചെയ്യാൻ കഴിയുന്നതും എന്നാൽ അതിൻ്റെ അടിത്തറയായി ചില തത്വങ്ങൾ നിലനിൽക്കുന്നതുമായ ഒരു അപ്രോച്ചിന് മാത്രമേ നീതിയെ ഉറപ്പ് ചെയ്യാൻ പറ്റൂ. ഇന്ത്യയെ സംബന്ധിച്ച് നമ്മൾ ആലോചിക്കുമ്പോൾ ഇത്തരമൊരു ഈ പൊതു തത്വം എങ്ങനെയാണ് രൂപം കൊള്ളുന്നത് എന്ന് നമ്മൾ ആലോചിച്ചാൽ, അതൊരു സമൂഹം, വാട്ട് ഈസ് എ ഹ്യൂമൻ ബീയിങ്, ഒരു മനുഷ്യൻ എന്താണ് എന്ന ചോദ്യത്തിന് ഒരു ജനത പിന്തുടരുന്ന ഉത്തരമാണ് ഇത്തരം ഒരു പൊതു തത്വത്തെ, നമുക്കെല്ലാവർക്കും തുല്യതയും തുല്യ അവസരവും തുല്യ അന്തസ്സും തുല്യ പരിഗണനയും ഉള്ള ഒരു തത്വത്തെ ഒരു സമൂഹത്തിൽ സാധ്യമാക്കുന്നത്. ആ സമൂഹം, വാട്ട് ഈസ് എ ഹ്യൂമൻ ബീയിങ്, എന്താണ് മനുഷ്യൻ, ആരാണെന്നുള്ളതല്ല, എന്താണ് മനുഷ്യൻ എന്ന ചോദ്യത്തിന് തത്വശാസ്ത്രപരമായോ അതിഭൗതികവാദപരമായോ തിയോളജിക്കലായിട്ടോ കൊണ്ട് നടക്കുന്ന, അവർ സ്വരൂപിച്ചിട്ടുള്ള ഉത്തരത്തിലാണ് ഇതിന്റെ വേരുകൾ കിടക്കുന്നത്. ആ നിലക്കാണ് ഇന്ത്യൻ നീതി സങ്കല്പത്തെ നമ്മൾ പരിശോധിക്കേണ്ടത്. ഇത് പരിശോധിക്കുമ്പോഴാണ് ഇന്ത്യയിൽ എന്തുകൊണ്ട് നമുക്കിതുപോലൊരു വെബിനാർ നടത്തേണ്ടി വരുന്നു എന്ന ചോദ്യത്തിന്റെ ഉത്തരം പോലും അതിനകത്താണുള്ളത്. എന്ന് പറഞ്ഞാൽ ആധുനിക ഇന്ത്യയുടെ പതിറ്റാണ്ടുകൾ കഴിഞ്ഞിട്ടും നീതി യഥാർത്ഥത്തിൽ നടപ്പിലാകുന്നുണ്ടോ എന്ന ചോദ്യത്തിന് ഉത്തരം തേടേണ്ടി വരുന്ന ഒരവസ്ഥ നമ്മുടെ മുന്നിൽ ഉള്ളത് പോലും ഞാൻ വിചാരിക്കുന്നത് ഇന്ത്യയെ സംബന്ധിച്ച്, ഇന്ത്യയുടെ ചരിത്രത്തിൽ, അതിൻ്റെ തത്വശാസ്ത്ര ചരിത്രത്തിൽ, അതിൻ്റെ മെറ്റാഫിസിക്സിന്റെ ചരിത്രത്തിൽ, അതിൻ്റെ സാംസ്കാരിക പാരമ്പര്യത്തിൽ മനുഷ്യൻ എന്നത് അടയാളപ്പെട്ടിരിക്കുന്നത് അവർ ഓണ്ടോളജിക്കലി ഇഗാലിറ്റേറിയൻ അല്ല എന്ന് പറഞ്ഞുകൊണ്ടാണ് തുടങ്ങുന്നത്. ഇന്ത്യയിലെ മനുഷ്യർ, ലോകത്തിലെ മനുഷ്യർ സത്താപരമായി തുല്യരല്ല എന്ന് പ്രഖ്യാപിച്ചുകൊണ്ടും അതിനെ കണ്ടെയ്ൻ ചെയ്തുകൊണ്ടുമാണ് നമ്മുടെ സാമൂഹിക ആലോചനകൾ, സാംസ്കാരിക ആലോചനകൾ, നീതി സങ്കല്പങ്ങളൊക്കെ നമ്മൾ തുടങ്ങുന്നതിന് മുൻപ് തന്നെ നമ്മൾ കൺസീവ് ചെയ്ത് വെച്ചിരിക്കുന്ന ഒരു ഐഡിയ വി ആർ നോട്ട് ഈക്വൽ എന്നാണ്. നമ്മൾ ജന്മനാ തന്നെ തുല്യരല്ല എന്ന് വിചാരിക്കുന്ന ഒരു സമൂഹമാണെന്ന്. ഇത് വളരെ വളരെ പ്രധാനപ്പെട്ട ഒരു കാര്യമാണ് ഈ ചർച്ചയിലെന്ന് ഞാൻ വിചാരിക്കുന്നു. അങ്ങനെ വിചാരിക്കുന്ന ഒരു സമൂഹത്തിന് നമ്മളെല്ലാവരും തുല്യരല്ല എന്ന് മാത്രമല്ല, ചിലർ ആദരിക്കപ്പെടേണ്ടവരും ദൈവതുല്യരായി കാണപ്പെടേണ്ടവരും, മറ്റു ചിലർ ഉപേക്ഷിക്കപ്പെടേണ്ടവരും മനുഷ്യരായി പരിഗണിക്കാൻ പാടില്ലാത്തവരും ആണ് എന്ന് വിചാരിക്കുന്ന ഒരു സമൂഹത്തിനകത്ത് എങ്ങനെയായിരിക്കും നീതി എന്നത് പ്രവർത്തിക്കുക എന്നത് നമുക്ക് ഊഹിക്കാവുന്നതേ ഉള്ളൂ. അപ്പൊ ഞാൻ പറയുന്ന ഒരു പോയിന്റ് ഇതാണ്, നമ്മളുടെ മനുഷ്യ സങ്കല്പം, നമ്മുടെ സമൂഹ സങ്കല്പം അടിസ്ഥാനപരമായി തത്വചിന്താപരമായി തന്നെ നീതിയെ നിഷേധിക്കുന്ന പില്ലറിലാണ് കെട്ടിപ്പൊക്കിയിരിക്കുന്നത്. അതിനൊരിക്കലും ചണ്ടാളനോ അവർ കരുതുന്ന, ആ തത്വചിന്ത കരുതുന്ന ബഹിഷ്കൃത മനുഷ്യർക്ക് നീതി ലഭ്യമാക്കാൻ കഴിയില്ല എന്ന് മാത്രമല്ല, അവർക്ക് നീതി ലഭ്യമാക്കാതിരിക്കുന്നത് എൻ്റെ കടമയാണെന്ന് വിചാരിക്കുന്ന മനുഷ്യരിൽ നിന്ന് നമ്മൾ എന്ത് നീതിബോധമാണ് പ്രതീക്ഷിക്കുന്നത്? അവരിൽ നമുക്ക് അവർ നീതി ഇല്ലാത്തവരല്ല, അവർ ചിലർക്ക് മാത്രമേ നീതി കൊടുക്കൂ. ഇതാ പ്രശ്നം. അവർ ചില സന്ദർഭങ്ങളിൽ മാത്രമേ നീതിബോധമുള്ള പൗരനായി ഉണരൂ. ചിലർക്ക് മാത്രമേ നീതി നിർബന്ധമായി അവർ ഡെലിവർ ചെയ്യൂ. മറ്റു ചിലരുടെ മേൽ നടക്കുന്ന അനീതിയാണെന്ന് പോലും തോന്നാൻ കഴിയാത്ത വിധം വിചിത്ര മനുഷ്യ സ്വത്വങ്ങളെയാണ് ജാതി നിർമ്മിച്ച് നമുക്ക് നൽകിയിരിക്കുന്നത് എന്ന വളരെ പ്രധാനപ്പെട്ട ഒരു പോയിന്റ് നമ്മൾ ഇതിൽ കൂട്ടി കാണണം. അങ്ങനെ ഒരു എങ്കിൽ മാത്രമേ ഈ കോടതിയിലെ വിധികൾ അതിവിചിത്രമായി നമുക്ക് തോന്നുന്ന, ഏറ്റവും നീതി നിഷേധിക്കുന്നു എന്ന് പ്രത്യക്ഷത്തിൽ തോന്നുന്ന വിധമുള്ള, വിധികളിൽ നമ്മൾ അത്ഭുതപ്പെടേണ്ടതില്ല. അവരിൽ നിന്ന് അത്തരം വാക്കുകളെ ഉണ്ടാകൂ. അതിന്റെ കാരണം അവരാരും വ്യക്തിപരമായി മോശക്കാരായതുകൊണ്ടല്ല, മറിച്ച് അവർ പിന്തുടരുന്ന എത്തിക്കൽ കോഡ്, അവർ പിന്തുടരുന്ന തത്വശാസ്ത്ര ബോധം, അവർ പിന്തുടരുന്ന സാമൂഹികത. ആ സാമൂഹികത എന്ന് നോക്കിയ ഡോക്ടർ BR അംബേദ്കർ പറഞ്ഞു, ഇന്ത്യൻ സമൂഹത്തിന്റെ അടിസ്ഥാനപരമായ പ്രകൃതം അവിടെ അസമത്വമുണ്ട് എന്നതല്ല, മറിച്ച് അസമത്വത്തെ ന്യായീകരിക്കുന്ന വലിയൊരു വ്യവഹാര മണ്ഡലമുണ്ട് എന്നതാണ്. അത് അദ്വൈതം മുതൽ അമ്മൂമ്മ കഥ വരെ വ്യാപിച്ചു കിടക്കും. അതിൽ നിന്നും നമുക്ക് ഒട്ടനവധി എത്തിക്കൽ കോഡുകൾ നമ്മൾ ദൈനംദിന ജീവിതത്തിൽ കൺസീവ് ചെയ്യും. ഞാനൊരു ചെറിയൊരു ഉദാഹരണം പറഞ്ഞാൽ, നമ്മുടെ അമ്മൂമ്മ കഥകൾ പറഞ്ഞ പണ്ട് ഒരു ഗ്രാമത്തിൽ ഒരു ശുദ്ധനായ ബ്രാഹ്മണൻ ഉണ്ടായിരുന്നു. നിങ്ങൾ വേറെ എവിടെയെങ്കിലും കേട്ടിട്ടുണ്ടോ പണ്ട് ഒരു ഗ്രാമത്തിൽ ശുദ്ധനായ ഒരു ദളിതനുണ്ടായിരുന്നു, ഒരു നിഷാദനുണ്ട്? കേട്ടിരിക്കാൻ ഒരു വഴിയുമില്ല. അങ്ങനെ കഥ നമുക്കില്ല. നമ്മുടെ വൈകാരിക പ്രപഞ്ചത്തെ പോലും ബ്രാഹ്മണനും ബ്രാഹ്മണ ചിന്തയ്ക്കും അനുകൂലമാക്കി മാറ്റുന്ന അമ്മൂമ്മ കഥകളിലാണ് നമ്മൾ ജീവിക്കുന്നത്. അങ്ങനെ ജീവിക്കുമ്പോൾ ഈ ബ്രാഹ്മണർ ദൈവങ്ങളായി മാറുന്നു എന്നുള്ളതാണ് നമ്മുടെ മുന്നിലൊരു പ്രശ്നം. നിങ്ങൾ ശ്രദ്ധിച്ചിട്ടുണ്ടോ? കേരളത്തിലെ പബ്ലിക് സ്പേസിൽ ഷർട്ടിടാതെ നടക്കുന്നത് ആരാണ്? ബ്രാഹ്മണർ മാത്രമാണ്. എന്തുകൊണ്ടായിരിക്കും അവർ ഷർട്ടിടാതെ നടക്കുന്നത്? ഞാൻ പറയാം, രാവിലെ ഒരു 6 മണിക്കാകുമ്പോൾ തൃശ്ശൂരോ തിരുവനന്തപുരത്തോ കോഴിക്കോടോ ഏതെങ്കിലും പട്ടണത്തിൽ ഇറങ്ങി വെറുതെ നോക്കി നിന്നാൽ ഷർട്ടിടാതെ സ്കൂട്ടറിൽ പോകുന്ന കുറെ മനുഷ്യർ കാണാം. അവരെന്തുകൊണ്ടായിരിക്കും ഷർട്ടിടാത്തത്? ഈ ആധുനിക സമൂഹത്തിനകത്ത് അവർ മാത്രമാണ് ഷർട്ടിടാതെ പബ്ലിക് സ്പേസിലേക്ക് വരുന്നത്. അതിനൊറ്റ കാരണമേ ഉള്ളൂ, അവരുടെ ശരീരത്തിൽ കിടക്കുന്ന പൂണൂലിന്റെ കനത്ത സിംബോളിക് വാല്യൂ ആണ്. അത് സമൂഹ മധ്യത്തിൽ സ്ഥാപിക്കുന്ന ഒരാക്റ്റാണ് ഷർട്ടിടാതെ അവർ പുറത്തു വരുന്നതിന്റെ കാര്യം. നമ്മളൊന്ന് ഷർട്ടിടാതെ നടന്നു നമ്മൾ അന്നേരം അറിയാൻ വരും. നമ്മൾ ഷർട്ടിടാതെ അന്നേരം തടഞ്ഞു വെക്കും, പോയി ഷർട്ടിട്ടിട്ട് വരാൻ പറയും, നിർബന്ധമായി പറയും. പക്ഷെ ഈ ബോഡിയെ നമുക്ക് തടഞ്ഞു നിർത്താൻ പറ്റില്ല. കാരണം അത് പാവനമായ ബോഡിയാണ്, തിരുമേനിയാണ്, വെറും മേനിയല്ല. ഇങ്ങനെ നമ്മളുടെ കാഴ്ചയിൽ, വർത്തമാനങ്ങളിൽ, ദൈനംദിന പെരുമാറ്റങ്ങളിലൊക്കെ ഈ സംഭവം, ഈ മൂല്യബോധം, സവർണൻ ആദരിക്കപ്പെടേണ്ടവരാണെന്നും അവർക്കാണ് ഈ സമൂഹത്തിൽ സ്ഥാനമുള്ളതെന്നും അവരാണ് മുന്തിയ മനുഷ്യരെന്നും ദൈനംദിനം ഓർമ്മിപ്പിക്കുന്ന ഒരു പരിസരമാണ് നമുക്കുള്ളത്. ഒരു ജഡ്ജിയും ആ പരിസരത്തിൽ നിന്ന് പുറത്തല്ല. അത് നമ്മൾ അറിയേണ്ട കാര്യം. നമുക്ക് ഈ വ്യക്തികൾ എന്തുകൊണ്ടാണ് ഈ നീതിബോധമില്ലാതെ പെരുമാറുന്നത് എന്ന് ചോദിച്ചാൽ അതിനൊറ്റ കാരണമേ ഉള്ളൂ, അവരുടെ വിദ്യാഭ്യാസം അതിനൊരു തടസ്സമല്ല. MA കാരനാണ്, PhD കാരനാണ്, LLB കാരനാണെന്നുള്ളതൊന്നും ഈ വിവേചനങ്ങളെ ആന്തരവൽക്കരിക്കുന്നതിൽ കൊണ്ടു നടക്കുന്നതിൽ അവർ തടസ്സപ്പെടുത്തുന്നില്ല എന്ന് പറഞ്ഞാൽ അവർ വ്യക്തിപരമായി കൊണ്ടു നടക്കുന്ന മൂല്യബോധമാണ് അവരെ നല്ല മനുഷ്യരോ ചീത്ത മനുഷ്യരോ ആക്കി മാറ്റുന്നത്. അപ്പൊ ഇക്കാര്യത്തിൽ ഈ ദളിതനോട് നീതി കൊടുക്കേണ്ടതില്ല എന്ന കാര്യത്തിൽ അവർക്കാർക്ക് തർക്കമില്ലാത്തത് കൊണ്ട് അവർ PhD കാരായാലും ഒരു നീതി കൊടുക്കാതെ തന്നെ ഇരിക്കും. ഇവിടെയാണ് പ്രശ്നം. രണ്ടാമതൊരു കാര്യം ഞാൻ പറഞ്ഞ ഒരു പോയിന്റേ ഉള്ളൂ. നമ്മുടെ സമൂഹത്തിന്റെ മൊത്തം പ്രകൃതം തന്നെ നീതിയെ ന്യായമായി വിതരണം ചെയ്യാൻ കഴിയുന്ന ഒരു ഘടനാവിശേഷത്തിലല്ല നമ്മൾ ജീവിക്കുന്നത്. നമ്മുടെ ഭാവന പോലും അങ്ങനെയാണ് ക്രമീകരിക്കപ്പെട്ടിരിക്കുന്നത്. എൻ്റെ ഒന്നാമത്. രണ്ടാമതൊരു കാര്യം, നമ്മുടെ സ്ഥാപനങ്ങളിൽ എന്തുകൊണ്ടാണ് സ്ഥാപനങ്ങളുടെ നീതിയുടെ പ്രവർത്തനം അങ്ങനെയാണ് നടക്കുന്നത്? നമുക്കറിയാം, സ്ഥാപനങ്ങളെ അത് കോടതിയായാലും വിദ്യാഭ്യാസ സ്ഥാപനമായാലും നമ്മുടെ ഈ ഉദ്യോഗസ്ഥ മേഖലകളായാലും ഈ സ്ഥാപനങ്ങളുടെ നീതി വിതരണം ചെയ്യാൻ കൃത്യമായൊരു സംവിധാനമുണ്ട്. അതിന് നിയമങ്ങളുണ്ട്, അതിന് തത്വങ്ങളുണ്ട്. ഒരാളുടെ മുന്നിൽ, ഒരു ജഡ്ജിയുടെ മുന്നിൽ ഒരു പരാതി വന്നു കഴിഞ്ഞാൽ അത് എങ്ങനെ കാണണം എന്നതിനെ സംബന്ധിച്ച് കൃത്യമായ നിയമങ്ങളും അതിൻ്റെ ഡയറക്ഷൻസും ഒക്കെ ഉണ്ട്. അതില്ലാത്തത് കൊണ്ടല്ല. ഇതൊക്കെ ഉണ്ടായിരിക്കെ, ഇതൊക്കെ ഉണ്ടെങ്കിലും അതിനെപ്പോലും കവിഞ്ഞു നിൽക്കുന്ന ഈ ജാതി ബോധം, കവിഞ്ഞു നിൽക്കുന്ന സവർണ ബോധം നമ്മളുടെ ഈ എല്ലാ തരത്തിലുള്ള സ്ഥാപനങ്ങളെയും ബാധിക്കും. ഇപ്പോ ഒരു കലാലയത്തിൽ അധ്യാപകൻ എങ്ങനെയാണ് വിദ്യാർത്ഥികളോട് പെരുമാറേണ്ടത് എന്നതിന് കൃത്യമായ കോഡുണ്ട്. വിദ്യാർത്ഥികളോട് അപമര്യാദയായി പെരുമാറാൻ പാടില്ല, വിവേചനം കാണിക്കാൻ പാടില്ല. അതാണ് ഒരു ആധുനിക സമൂഹത്തിന്റെ ലക്ഷണം. പക്ഷെ ഈ വരുന്ന അധ്യാപകൻ അത്ഭുത ജന്തു അല്ല എന്ന് നമ്മൾ അറിയണം. ഇയാള് വീട്ടിലും അയാളുടെ നാട്ടിലും അയാളുടെ അമ്പലത്തിലും ഒരു നായർ പ്രമാണിയുടെ ബോധത്തെ നിരന്തരം കൊണ്ടു നടന്നതിനെ താലോലിക്കുന്ന ഒരാളാണ് ഈ ആധുനിക സ്പേസ് ആയിട്ടുള്ള ഇതിലേക്ക് കടന്നു വരുന്നത്, ക്ലാസ്സിലേക്ക് കടന്നു വരുന്നത്. അയാൾക്ക് ആ ബോധം പുറത്ത് വെച്ചിട്ടല്ല കയറി വരുന്നത്. പിന്നെ നിവൃത്തിയില്ലാത്തത് കൊണ്ട് ഈ ബാക്കി ആരെയും ജാതിയിൽ വിവേചിക്കുന്നവരെ കൊല്ലുന്നില്ല, തല്ലുന്നില്ല എന്ന് മാത്രമേ ഉള്ളൂ. യഥാർത്ഥത്തിൽ അവർക്ക് കൊല്ലണം തന്നെ അവർ വിചാരിക്കുന്നത്. അങ്ങനെയാണ് രോഹിത് വെമുലയെ പോലെ ഒരാൾ ആത്മഹത്യ ചെയ്യേണ്ടി വരുന്നത്. രോഹിത് വെമുലയ്ക്കെതിരെ നടപടിയെടുക്കണമെന്ന് പറഞ്ഞ് കേന്ദ്ര ഗവൺമെന്റിന്റെ ഓഫീസിൽ നിന്നും, സ്മൃതി ഇറാനിയുടെ ഓഫീസിൽ നിന്നും 7 കത്തുകളാണ് വന്നത്. ഒരു വിദ്യാർത്ഥിയെ പുറത്താക്കും. ഒന്ന് ഓർക്കണം, എത്ര ഷാർപ്പാണ് പറഞ്ഞത്. എന്താണ് നമ്മുടെ കേന്ദ്ര മന്ത്രാലയത്തിന് ഇത്ര താല്പര്യം ഈ കുട്ടികളെ പുറത്താക്കണമെന്ന്? അപ്പോ പ്രശ്നം എന്താണെന്ന് ചോദിച്ചാൽ ഇവരെയൊക്കെ ഭരിക്കുന്നത് ഈ ബോധ്യമാണ് എന്നതാണ് സ്ഥാപനങ്ങളും നേരിടുന്ന ഒരു വെല്ലുവിളി. അതുകൊണ്ട് ഇന്ത്യൻ കോടതി കഴിഞ്ഞ ദിവസം ഒരു കോടതി ഒരു ഇത് നടത്തി. ഒരു ബലാത്സംഗവും സ്ത്രീ പീഡനവുമായി ബന്ധപ്പെട്ട കേസിൽ കോടതി പറഞ്ഞു, പ്രതി ഭാര്യയെ കൂട്ടി ഇരയുടെ വീട്ടിൽ ചെന്ന് ആ ഇരയിൽ നിന്നും ഇയാളുടെ കയ്യിലേക്ക് ഒരു ചരട് കെട്ടിക്കണം, എന്നിട്ട് സഹോദരിയെ പ്രഖ്യാപിക്കണം. എന്ത് വിചിത്ര ജന്തുവാണ് ഈ കക്ഷി! നമ്മൾ നോക്കണം. ഇയാളുടെ തലയിൽ അതേ ഉദിക്കൂ. ഇതാണ് പ്രശ്നം. അപ്പൊ ഇന്നലെ ഹൈക്കോടതി, കർണാടകയാണെന്ന് തോന്നുന്നു, കോടതി ഒരു വിധി വന്നു. ഇപ്പൊ സ്ത്രീകൾക്ക് പുറത്തിറങ്ങി നടക്കാൻ പാടില്ല. വേദകാലഘട്ടമായിരുന്നു ഇതിനേക്കാൾ നല്ലതെന്നായി. കാര്യങ്ങൾ ഒളിച്ചു കിടത്തുന്നത് എങ്ങനെയാണ് നമ്മൾ മനസ്സിലാക്കിക്കോളും. ഈ വേദകാലഘട്ടം എന്ന് പറഞ്ഞു കഴിഞ്ഞാൽ മനുഷ്യനെ പിടിച്ചുകൊണ്ടുവന്ന നരബലി നടത്തിക്കൊണ്ടിരുന്ന കാലമാണെന്ന് ഓർക്കണം. പക്ഷെ അദ്ദേഹം പറയുന്നത് വേദകാലഘട്ടം എന്തോ സുന്ദരമായ കാലഘട്ടമായിരുന്നു, നമ്മുടെ കാലഘട്ടം വളരെ മോശമാണ് എന്നല്ല. ഇതൊന്നും യാദൃച്ഛികമായി സംഭവിക്കുന്നതല്ല. ഒരു കാര്യം ഞാൻ പറയുന്നത്, അതുകൊണ്ട് സ്ഥാപനങ്ങൾ അതിന്റെ തത്വത്തെ പിന്തുടരുന്നതിൽ നിന്നും സ്ഥാപനങ്ങളെ വിലക്കുന്ന നീതി നിഷേധത്തിന്റെ ഒരു ഘടന നമ്മുടെ എല്ലാ സ്ഥാപനങ്ങളും അതുകൊണ്ട് അവിടെയും നീതി വിതരണം ചെയ്യാൻ കഴിയാതെ വരുന്നു എന്നതാണ്. ഈ നീതി വിതരണം ചെയ്ത് അവർക്ക് നീതി കൊടുക്കേണ്ടതില്ല എന്നുള്ളത് ബാക്കിയുള്ളവരുടെ സങ്കല്പം. ഈ കീഴ്ത്തട്ടിന് നീതി കൊടുക്കുക, അതുകൊണ്ട് അവർക്ക് ഭൂമി കൊടുക്കാറില്ല. ഇപ്പൊ കേരളത്തിൽ വിചിത്രമായൊരു സമരം നടക്കുന്നുണ്ട്. വയനാട്ടിലെ ആദിവാസി കുട്ടികൾ 2000-ലധികം കുട്ടികളാണ് SSLC പാസ്സായത്. 550 സീറ്റേ ഉള്ളൂ +1. ഇതൊന്ന് പരിഹരിക്കണം എന്ന് പറഞ്ഞാൽ ഗവൺമെന്റ് എന്നാലും അടിയന്തരമായി ഇടപെട്ട് പരിഹരിക്കേണ്ടതാണല്ലോ. ഗവൺമെന്റ് ഇടപെടുന്നില്ല. വിദ്യാർത്ഥികൾ 23 ദിവസമായി സമരത്തിലാണ്. ഇതെന്തൊരു വിചിത്രമായ നാടാണ് നമ്മൾ ആലോചിക്കണം. കുട്ടികൾക്ക് പഠിക്കണം എന്ന് പറഞ്ഞിട്ട് സമരം ചെയ്യേണ്ടി വരുന്ന, ഇപ്പോഴും സമരം ചെയ്യേണ്ടി വരുന്ന ഒരു നാടാണ് നമ്മുടേത്. അത് നീതിപൂർവമായി പരിഹരിച്ചു കൊടുക്കേണ്ടതാണെന്ന് ഒരാളും വിചാരിക്കാത്ത നാടാണ്. അത് നമ്മുടെ സ്ഥാപനത്തിൽ തന്നെ ഇത്രയും എലമെന്റുകൾ, അതായത് ഞാൻ നേരത്തെ പറഞ്ഞ ഗ്രേഡഡ് ഇൻഇക്വാളിറ്റിയുടെ എലമെന്റുകൾ, ബോധ്യങ്ങൾ വളരെ വ്യക്തമായും പ്രവർത്തിക്കുന്നത് കൊണ്ടാണ് കോടതി പോലും പല സമയങ്ങളിലും കോൺസ്റ്റിറ്റ്യൂഷൻ മൊറാലിറ്റിയെ പോലും ഉപേക്ഷിച്ചുകൊണ്ട്, ഭരണഘടനാ ധാർമ്മികതയെ ഉപേക്ഷിച്ചുകൊണ്ട് മെജോറിറ്റേറിയൻ മൊറാലിറ്റിയെ ഉയർത്തിപ്പിടിക്കുന്ന ഒരു സന്ദർഭത്തിലാണ് ഇപ്പോൾ നമ്മൾ ജീവിക്കുന്നത്. കഴിഞ്ഞ കുറെ ദിവസങ്ങളായി വരുന്ന പ്രധാനപ്പെട്ട വിധികളെല്ലാം മെജോറിറ്റേറിയൻ മൊറാലിറ്റിയെ കാത്തു സൂക്ഷിക്കുന്ന, അതിനെ അംഗീകരിക്കുന്ന, അതിനെ ആദരിക്കുന്ന ഒരു കാര്യമാണ്. ഡോക്ടർ BR അംബേദ്കർ കോൺസ്റ്റിറ്റ്യൂഷൻ അസംബ്ലി പറഞ്ഞു, ഭരണഘടനാ ധാർമ്മികത എന്നത് സ്വാഭാവികമായി നമുക്ക് കൈവരുന്ന ഒന്നല്ല, അത് നമ്മൾ നട്ട് നനച്ച് വളർത്തേണ്ടതാണ്. ആ മൊറാലിറ്റി കോൺസ്റ്റിറ്റ്യൂഷൻ മുന്നോട്ട് വെക്കുന്ന ആ ധാർമ്മികത, എല്ലാവരും തുല്യരാണ്, എല്ലാവർക്കും തുല്യാവസരം ഉണ്ടാകണം, എല്ലാവർക്കും നീതി ഒരുപോലെ വിതരണം ചെയ്യണം തുടങ്ങിയ ആ ധാർമ്മികത ഇന്ത്യയിലെ ഓരോ പൗരരിലും പ്രവേശിച്ചു കഴിഞ്ഞാൽ മാത്രമേ നമ്മളുടെ ജനാധിപത്യം പൂർണ്ണമായി ഫങ്ഷൻ ചെയ്യൂ എന്ന് ഡോക്ടർ BR അംബേദ്കർ എന്ന് തന്നെ പറയുന്നു. അപ്പോൾ നമ്മൾ നേരിടുന്ന ഒരു പ്രശ്നം, ഈ വ്യവസ്ഥയും നീതിയും തമ്മിൽ വലിയൊരു വിടവുണ്ട്. അതിന്റെ പ്രധാനപ്പെട്ട ഒരു കാരണം, ആ വ്യവസ്ഥയുടെ നടത്തിപ്പുകാർ ഈ കോൺസ്റ്റിറ്റ്യൂഷണൽ നീതിയെ അംഗീകരിക്കുന്നവരല്ല എന്നതാണ്. അവരെ സംബന്ധിച്ചിടത്തോളം ജാതി നിയമങ്ങൾ തന്നെയാണ് അവരിപ്പോഴും പിന്തുടരുന്നത്. എത്ര ഉന്നതനായാലും അതിനെ ബ്രേക്ക് ചെയ്യുന്ന മനുഷ്യർ വളരെ അത്യപൂർവമായി ഇന്ത്യയിൽ പ്രവർത്തിച്ചിട്ടുള്ളൂ എന്നത് നമുക്ക് വളരെ പ്രധാനമായും കാണുവാൻ പറ്റും. ഈ 2 പോയിന്റാണ് ഈ ചർച്ചയിൽ ഞാൻ പറഞ്ഞത്. ഒന്ന്, നമ്മുടെ പ്രകൃതം തന്നെ ഈ ജസ്റ്റിസ് എന്ന സങ്കല്പത്തെ അട്ടിമറിക്കുന്നവർ. ജസ്റ്റിസ് ഇല്ലാത്തൊരു സമൂഹമല്ല നമ്മുടേത്, മറിച്ച് ജസ്റ്റിസ് ചിലർക്ക് മാത്രം, സെലക്റ്റീവായി മാത്രം വിതരണം ചെയ്യുന്ന ഒരു സ്ഥലമാണ്. അങ്ങനെയാണ് നമ്മുടെ തത്വചിന്തയും നമ്മുടെ ഇതിഹാസങ്ങളും പുരാണങ്ങളും എല്ലാം നമ്മളെ പഠിപ്പിക്കുന്നത്. എല്ലാവർക്കും നീതി കൊടുക്കേണ്ടതില്ല എന്ന് തന്നെ. അതിനെയാണ് ഇവർ ഫോളോ ചെയ്യുന്നത്. നമ്മുടെ സ്ഥാപനങ്ങളാവട്ടെ, സ്ഥാപനങ്ങൾക്ക് കൃത്യമായ നിയമങ്ങളും കാര്യങ്ങളും ഒക്കെ ഉണ്ടെങ്കിലും ആ നിയമത്തെ ആ സ്ഥാപനം നടത്തിക്കൊണ്ട് പോകുന്നവർ ശരിയായ രീതിയിൽ ഫോളോ ചെയ്യുന്നില്ല എന്ന് മാത്രമല്ല, അതിന്റെ മൂല്യങ്ങളെ നിരന്തരമായി അട്ടിമറിക്കുന്ന പ്രവർത്തനങ്ങൾ അവർ ഏർപ്പെട്ടുകൊണ്ടിരിക്കും. അവിടെ സ്ഥാപനങ്ങൾ, നീതി വിതരണം ചെയ്യാൻ ഉത്തരവാദിത്തപ്പെട്ട സ്ഥാപനങ്ങളുടെ നടത്തിപ്പ് രീതികളും ജനങ്ങളുടെ അവസ്ഥയും തമ്മിൽ വളരെ വലിയൊരു ഗ്യാപ്പ് ഇന്ത്യയിലുണ്ട്. ഇത് പരിഹരിക്കാൻ നമുക്ക് കഴിയണമെങ്കിൽ ഇന്ത്യയുടെ തന്നെ ഈ മനുഷ്യ സങ്കല്പത്തെയും ഈ ബ്രാഹ്മണ സേവ എന്ന് പറയുന്ന, നമ്മളെ ഒരു കാര്യം കൂടി പറഞ്ഞു ഞാൻ അവസാനിപ്പിക്കാം. ഇന്ത്യക്കകത്ത് നിങ്ങൾ ശ്രദ്ധിച്ചിട്ടുണ്ടോ, ഇന്ത്യയിലെ ഒട്ടനവധി ഇതിഹാസങ്ങളും ഒരു കാര്യം പറയാം. ഈ പഴംപുരാണങ്ങളിൽ, മഹാഭാരതം, രാമായണം തുടങ്ങിയ സംഗതികളിൽ ബ്രാഹ്മണ സേവ വേണ്ടെന്ന് പറയുന്ന ഒരു പുസ്തകം പോലും നമുക്ക് കാണാൻ പറ്റില്ല. അതാണ് നമ്മുടെ മഹത്തായ പാരമ്പര്യമായി നമ്മൾ കൊണ്ടുവന്നത്. വളരെ നേരിട്ട് പറഞ്ഞിരിക്കുകയാണ്, ബ്രാഹ്മണൻ കാണപ്പെട്ട ദൈവമാണ്, അവനെ ആദരിക്കുക, അവന് ദാനം ചെയ്യുക, അവന് ഭൂമി കൊടുക്കുക, അവന് അധികാരം കൊടുക്കുക, അവനെ ദൈവത്തെ പോലെ കരുതുക എന്ന് പറയാത്ത ഒരു ഗ്രന്ഥം പോലും, എല്ലാ ഗ്രന്ഥവും തന്നെയാണ് പറയുന്നത്. അത് മ്ലേച്ഛമായൊരു കാര്യമാണ് എന്ന് ഇന്ത്യയിലെ ഒരു ബുദ്ധിജീവിക്ക് തോന്നുന്നില്ല. അവരും പറയുന്നത് ഇതെല്ലാം മഹത്തായ എന്തോ കാര്യമാണെന്നാണ്. ആ ഗ്രന്ഥങ്ങളുടെ ധർമ്മബോധത്തിൽ ജീവിക്കുന്ന ഒരാൾക്കും ഇന്ത്യയിലെ കീഴ്ത്തട്ട് സമൂഹത്തിനെന്ന് മാത്രമല്ല, ദുർബലമായ ഒരു വിഭാഗത്തിനും നീതി കൊടുക്കാൻ കഴിയില്ല. അവർ നീതിക്കെതിരായിരിക്കും എന്നതാണ് അതിന്റെ പ്രധാനപ്പെട്ട കാര്യം. അതുകൊണ്ട് ജുഡീഷ്യൽ ഏരിയയിൽ മാത്രം ഇടപെട്ടുകൊണ്ട് നമുക്ക് ഇതിന്റെ ഒരു പരിഹാരത്തിലേക്ക് നീങ്ങാൻ കഴിയില്ല. അതിന് വിശാലമായ ഇടപെടൽ. എങ്കിലും ജുഡീഷ്യറിക്കകത്ത് ഇതുപോലൊരു കോൺഷ്യസ്നസ് വളർത്താൻ വേണ്ടി നിങ്ങൾ തുടങ്ങി വെച്ചിരിക്കുന്ന ഈ പരിശ്രമം വളരെ പ്രധാനപ്പെട്ടതാണ് എന്ന് ഞാൻ വിചാരിക്കുന്നു. ആ മണ്ഡലത്തിലേക്ക് പലപ്പോഴും ഇത്തരം ചർച്ചകളൊന്നും കടന്നു വന്നിട്ടുണ്ടാവാൻ വഴിയില്ല എന്നാണ് ഞാൻ വിചാരിക്കുന്നത്. ആ ഒരു ധീരത ചരിത്രപരമായി വളരെ പ്രധാനപ്പെട്ടതാണ് എന്ന് പറഞ്ഞുകൊണ്ടും നിങ്ങളുടെ ഈ മഹത്തായ ദൗത്യത്തിൽ പങ്കാളിയാകുവാൻ നിങ്ങൾ എന്നെ ക്ഷണിച്ചതിനുള്ള നന്ദി രേഖപ്പെടുത്തിക്കൊണ്ട് നിർത്തുന്നു. നന്ദി, നമസ്കാരം.
വളരെ നന്ദി സണ്ണിയം കപ്പിക്കാട്. അദ്ദേഹം എന്തു പറഞ്ഞു എന്ന് ഇനി ചുരുക്കേണ്ട, വളരെ ലളിതമായി അദ്ദേഹത്തിന്റെ പോയിന്റുകൾ അവതരിപ്പിച്ചു. അപ്പൊ ഈ പ്രസന്റേഷനിൽ പങ്കെടുത്തതിന് വളരെ നന്ദി. ഞാൻ കൺക്ലൂഡിംഗ് റിമാർക്ക് അവസാനം പറയാം. അപ്പോ ലെറ്റ് മീ മൂവ് ഓൺ ടു ദ നെക്സ്റ്റ് പ്രസന്റർ, ഡോക്ടർ ബിനു പോൾ.
അദ്ദേഹം തുടങ്ങുന്നതിന് മുമ്പ് എനിക്ക് ഒരു വാക്ക് കപ്പിക്കാടിനോട് വീണ്ടും പ്രത്യേകിച്ച് നന്ദി പറയാൻ. അദ്ദേഹം ഈ വലിയ പ്രയാസങ്ങളിനുള്ളിൽ വന്നു, വളരെ വളരെ ഒരു മഹത്തായ 2-3 പോയിന്റ്സ് പറഞ്ഞു. സർ, വളരെ വളരെ നന്ദി. വെരി ഗ്രേറ്റ്ഫുൾ ടു യു സർ. താങ്ക് യു.
സണ്ണി സാർ തുടരുന്നുണ്ടോന്ന് പ്രതീക്ഷിക്കുന്നു, തുടരുമെന്ന് പ്രതീക്ഷിക്കുന്നു.
ഞാൻ കേൾക്കുന്നുണ്ട്. എനിക്ക് കേൾക്കാം.
So now moving on to Dr. Binu Paul. So he would be delivering his speech in English. Welcome, Binu Paul.
Thank you so much, Vidyut and Dr. Mohan Gopal for the introductions.
One minute, Mr. Binu Paul. Mohan Gopal sir, Sunny സാറിന്റെ മൈക്ക് ഒന്ന് ഓഫ് ചെയ്യണം. സണ്ണി സാറിന്റെ മൈക്ക് ഒന്ന്, ബാക്കിയുള്ള പാർട്ടിസിപ്പൻസിന്റെ മൈക്ക് ഒന്ന് മ്യൂട്ട് ചെയ്യണം. Okay, fine. Yes, Binu Paul, proceed.
Good. Yes, so thank you so much for the invite, and I think it was really nice to listen to what Mr. Sunny said. I'm quite different from all the other panelists in this panel discussion. For one, let's say mine is the academic interest on the socio-economic and socio-political antecedents and consequences of inequality and injustice, and some sloganeering which I did when I was as a student. I don't really have serious field experience to be able to give the rich experience and thoughts which was shared by the other panelists. Second is, it's fantastic to see that people can speak a lot about topics like this without a PowerPoint. The problem is, I've been teaching in a business school long enough where we come up with this idea that if you don't have a PowerPoint, your presentation is pointless and there is no power as well. I have a PowerPoint presentation, so I request Dr. Mohan Gopal to make me the presenter. Don't worry, there is no death by PowerPoint, just 2 slides to articulate my position. So while he does that, the introductions given by Vidyut and I have known each other for a quite long time. So whatever that he read about me is from the university website, which is meant for a different audience with whom I interact much more frequently. But I think in the context of this discussion that we are having, I probably require a different introduction. So first thing is, I'm a male, which means I have won a fair amount of a battle on the gender space. Second is I'm educated, and I hold a PhD degree from a university, which means I'm educated and I have some advantage on the education front. Third is me and my wife, we both are university professors. So thanks to the UGC pay scale, we are also financially comfortable. We are economically not disadvantaged. And here comes the most exciting part, which probably is very relevant to this discussion. The lady with whom I celebrated my wedding anniversary some 3-4 days back, she is from the so-called uppermost caste available in this country. She's a Tamil Brahmin. And if you think I've stopped bragging about my so-called socio-economic credentials, you're wrong. There's something more interesting. My parents, who are very devout Christians, are very proud of a small book which we have in our house. Now, this book, it basically traces our ancestors back and say that the first person who started this family was a Brahmin. Now, if we were to situate myself in a nice socio-economic space, a multi-dimensional socio-economic space, I'm in a fairly sweet spot. So this is my first slide. So this is my first slide. My first is, what's troubling me about a system that never discriminated against me? I mean, I've been very fortunate in multiple counts. But I must say that the current system has never given me any sort of troubles, but I still have a problem with it. And when I think of it, I think it's because of my initial experiences that I've had where I was growing up. I grew up in a place called Tingeli, which is near Tiruvalla. So my grandfather is the one who raised me. My parents were outside the state because of their work. So since my some land, a lot of people in the village knew us. And what I found out is that I was more inclined to be with, let's say when I was in school, I'm talking about when I was 6, 7 years old. I was more inclined to be with those kids who studied in the convent schools. Of course, I went to an aided school, nothing fancy, but an aided school. So the kids that I was hanging out with after school hours, we had a lot of fun. Some would call it mischief, but we had a lot of fun. And invariably, you will get caught sometimes. And what I found is this, whenever I was in trouble, the lineage that I have of being the grandson of this gentleman who was a school headmaster, an educated guy, and with some sort of middle class financial setup, that would come and save me. And people would say, we don't really expect from you because you're the grandson of this gentleman who was educated. Whereas my other friends who were with me in the same sort of trouble, they would be held accountable and punished. Punishment is not really was not very harsh, but still, they would report to their parents. They would sometimes be showered abuses. And I noticed a pattern. The pattern is, though I was getting into trouble more often than what is acceptable for someone of my age, I was not really getting punished as often as my other friends because of the, I don't know, the familiarity that people had or the respect that I had for my grandfather. And the corollary to that is, if me and somebody else is involved in the same transgression, and if I am allowed to go scot-free, and if that on account of my grandfather's position, the other person is actually being punished not because of his transgressions alone, it's because he does not have a grandfather as the one that I had. Now that troubles me. I'm quite comfortable with the thought that, okay, that I will not be getting punished because of who my grandfather is. But I'm uncomfortable with the position that somebody else who did something equal will get punished because their grandfather is not educated or not not from a socially acceptable family background. So my first slide is, I think I put it fairly okay. Rantings of an educated and financially comfortable male living in urban India. I live in this place called Lavasa. That's about 40, 50 kilometers from Pune. Fairly upmarket place. I think the average house cost somewhere about 1.5 crores. So this is a place where the old rich as well as the uber rich and the new rich of India, they buy a house as a vacation house. So this place, its original inhabitants, there are some of them who are still here. They live a very miserable life on many accounts. I mean, you simply cannot compare the lives. Now, when we talk about justice as a concept, what first came to my mind is, why am I troubled with my friends who were not very economically or who do not have comparable economic or socio-economic conditions as me? Why were they held accountable for the same transgressions? Why is that the people the original inhabitants of this particular place, Lavasa, don't have similar kind of lifestyle as opposed to the ones who come and buy a house here? I think the idea of justice essentially is what pricks me in all of these contexts. Of course, I'm referring to Amartya Sen's book, The Idea of Justice, as well. But more importantly, I think the society, as Mr. Sanika Picard said, the society that we live in has made certain systems, certain rules, the parameters of which could be based on caste, could be based on class, where the people who've been exposed to that kind of training whenever they interact with people or through institutions, the people believe that, okay, certain kind of people or certain people with certain backgrounds don't really need to be treated equal. And as Dr. Mohan Gopal and others very rightly said, that the courts of law, which is supposed to be taking care of this, if it is not doing it, if it's not doing that particular part, because of their exposure, the ones who are running the courts, because of their exposure, they're not doing that particular job well, then I think all of us have a reason to worry. It does not really matter if I'm an educated male living in urban India with acceptable social credentials. It doesn't matter if I'm not about it. So my second slide is is about this. I hope you can see this. Right. Now, these are some of the caste-based economic issues. I'm glad that the speakers before me addressed these in some detail. So where do we stand in terms of the philosophy, in terms of design and delivery of justice with regard to what I have put in the slides? Take a typical market economy, for instance. You have, let's say, simple, pure, plain place supply of demand and supply and demand of goods and services, including labor. Now, if the place or the caste that I'm born into is actually prohibiting me from taking up a different profession, which can be more rewarding, and if the social setup is not allowing you to do that, what sort of philosophy, what sort of design and delivery of justice can we currently see there? Now, I don't have answers to most of these questions. So if you take, for example, something like the role of the collective, right? So I think Mr. Kanchailaya very emphatically argued about the need to educate the next set of people who will be running the judicial system of a country about the need for justice that is devoid of the Savarna justice system, or the need to sensitize the people about the difficulties that people have from let's say the marginalized caste, and that can be done. It's not in the market's interest to probably do that, which means the governments will have to ensure the collective, which I would call as the government, who represents the collective, will need to mobilize public funds, will need to allocate and utilize public funds for that particular effort. Where do we stand in terms of our design and delivery with regard to the allocation, mobilization, utilization of resources for sensitizing the judiciary in terms of what is considered to be just for the oppressed society? So I think we can have, or rather, we need to have multiple rounds of discussions on this front. I'm going to limit my discussion only to what I see, or only to what you see on the PowerPoint. Primarily because of two reasons. One is, as I mentioned initially, that my exposure as an individual who's gone through, let's say, any sort of oppression, it's zero. Second, the intricacies of how do we make somebody come to the mainstream with active support of the systems. I think it will be incomplete unless we can economically empower them. So while a reservation, aka representation, in the government services and other things, or in the policy-making bodies, is being looked primarily as a means of representation, we cannot ignore, or we must not undermine the sort of economic freedom that it is given to, at least, or the economic hope it is given to the families of multiple families in the marginalized sections as to what they could become if they actually can make use of the provisions that are made available to them. So what I'm quite convinced about is, I think the struggles that we are going to that are going to be undertaken for achieving the cause of justice to the society as a whole, which treats every human being as a human being, irrespective of the caste, of the creed, of the community, the cuisine follow. I think it would require a broad consensus from the entire society, from the ones who have, from the ones who face these issues to the ones who probably can be sensitized. It's probably not very easy for us to make change the entire attitude of non-oppressed society or the oppressive classes. But I'm sure you'll be able to find change agents within those societies, like a Krishna who was mentioned earlier. I'm sure those things would happen if we have a bit more enriching discussions with people who also are very sympathetic to the cause, who really understand why these topics need to be discussed and debated at length. I think it is really important for us to have those kind of conversations as well. So while I don't have many solutions to offer, I really wish that this initiative takes a definite shape, goes forward, and addresses the multidimensional nature of injustice that currently prevails. There is no denying that. I was when I started this when I started listening to all the speakers, I had two fears in my mind. One is, one was because it's quite difficult to contribute anything really meaningful after listening to the likes of Panchayalaya, Mohan Gopal, and the other speakers. Second is, what if we are to definitely conclude that the judicial system in its current form leaves much to be desired in delivering justice to the marginalized class? What if we conclude that in affirmative? Well, I'm still leaving, or I'm still ending my presentation with both these fears still intact. At least it looks like there are very serious issues that need to be addressed from anecdotal evidences that have been presented here by the presenters. And I'm not really very sure if I contributed anything meaningful to the entire discourse. We should actually propel this movement forward. I would like to end by only stating this. We've heard this adage that Rome was not built in a day. What we also probably don't speak very often about is Rome was also not destroyed in a day. So just like we build a system brick by brick, I think if we want to rebuild or construct it again, you will probably need to do it brick by brick. And I'm sure we're going to require all the hands that we can get for this particular cause. So I'll end here, and I'm open to any suggestions or questions that you may have. Once again, thank you, and all the best to the organizers. And I hope that this becomes a continuous transaction process at the intellectual level and also at the policy making level. Thank you so much.
Thank you, Vinupal. Am I audible?
Yes, you are.
Yeah. Thank you, Vinupal. Okay, so light has gone here. Sorry. So I think Mohan Gopal sir could take over.
You've muted yourself.
No, unmute yourself.
Vidyut is an excellent moderator. He's keeps everyone. His eyes on everything, content and and systems. So I wanted to thank both speakers. രണ്ടുപേരും വളരെ important points ആണ് പറഞ്ഞത്. Mr. Sunny Kapikad, he himself said, both looked conceptually at the system from a sort of macro perspective. And Mr. Sunny Kapikad പറഞ്ഞത് the structure, the entire structure, social, administrative, governance, a structure of society is against giving justice, except to a few people on a few occasions for what they consider to be justice. It is not really a system meant to give equal justice under law to all citizens, which is the concept of the Constitution. I thought that's a very powerful point, because actually we have to explain why in 48 days after the tweet was sent, Prashant Bhushan was convicted by the highest court of this country of the crime of contempt of court. So this nowhere in the world could have proceeded so fast. All procedures were reorganized as necessary, because Mr. Bhushan had committed what was seen as by dominant powerful people in society, by some powerful people in society, as a grave social offense, namely insulting the high officials of the country as they saw it. And that was a wrong that had to be punished. In contrast, when a 19-year-old Dalit girl was simply helping her mother eke out their living by plucking grass from around their house, was brutally assaulted.
Sir, excuse me.
Yes,
Mohan Gopal sir, please switch off the mic of Vinupal and myself.
Okay.
You can proceed, sir. It is switched off.
Yes.
Okay.
Yes. Okay. So, yeah. Okay. So I was brutally assaulted. Her spine her tongue was cut, bitten off. Part of her tongue was bitten off, and she was left for dead. She goes to a hospital. The police don't, and she was then raped. Sorry, gang raped. She was then gang raped and taken to the hospital. She clearly says that I was gang raped. She names names of some of the people who are involved in the gang rape. All that is ignored. The doctors treat her. Again, all the crimes against her are ignored. They're they're not recorded. To another hospital in Delhi. Again, the negligence, both on the justice side and the medical side, continue. This is what newspapers have reported, and this whole matter is being examined by courts, but it's been reported by papers. So I'm not saying that what exactly the facts are will emerge, but from what we know, the contrast that this happens, then she finally dies, and she dies, then there is rapid movement again to take her body and dispose it off. There's a rapid movement on ensuring that the family doesn't speak. The rapid movement on building a defense, that there was some honor killing and so on and so forth. So we are dealing not with a system that doesn't work. We are dealing with a system that can work very fast when someone wants to, and very slowly when some people want it to work slowly. So I thought Mr. Sunny Kapikad provided a theoretical explanation for that a structure is actually there is, and that to me was a very innovative and insightful explanation, that it is a system that is supposed to give justice only to some people, not to all. So I want to thank him for that. And then he said, of course, these are the operators of the justice system, naturally are people who don't believe. Secondly, that what happens in instances where they don't see that as injustice at all. And so that takes us really to the what is the definition of justice? How do we understand justice? How do we understand caste? And this is probably some of the theoretical issues we should discuss in the next session when we will organize that. But and Dr. Binu Paul, of course, I also found his presentation extremely useful. He's reminding us that on one hand we are dealing with struggle for justice, and justice. The Chicago School of Economics and the economists there will not agree with me, but justice is at the end of the day a feat that even a small child has. If you take a piece of chocolate and break it into two unequal halves and give it to two children, then you know they this is not right. They will start protesting. There's something visceral, something primordial, something that I think ultimately impulse, ontological impulse of our very existence. We realize, we sense, even a small child senses that if I am not treated in a just manner, my very existence is at stake. And so it is not, so what gives quietus to that concern? What of injustice is what we refer to as justice, as a standard of human conduct that will not cause us this existential concern. Now, that existential concern is triggered biologically, but is constructed socially by different standards, and is based on a very complex set of psychological factors. And all that together, psychology, sociology, philosophy, history, and biology construct to this most important of all ideas of human society, idea of justice. And I think what he's pointing out to us is that in today's the realistic environment, a realistic understanding of the environment in which we live, we need to understand how to set out an economic framework in order to bring about this transformation from greater injustice to greater justice. And that includes looking at issues like resources, networks, institutional setups, path dependence, and livelihoods. So we have to look at various aspects so that we can develop a path for this transformation, which is very important. And so that also was, I think, adding a very good dimension to the struggle for justice and the struggle against injustice, which is at the heart of what we're discussing in this in this webinar. So I think thank you very much again, Dr. Binu Paul, for bringing us back to a very important framework in which we have to think about this transformation. And as drawing from what conservative, very eminent, renowned sociologist M.S. Srinivas said, we sort of extrapolating from his comments, we understand that actually what is going on is a very understandable struggle between two different ideas of justice. Some people are playing both systems and using both systems, and others are left out of both systems. They have neither system to protect them. So how to strategize on taking this struggle forward and make sure and make sure that how to make sure that we realize the constitutional vision of ensuring that the caste marginalized communities are able to secure justice as envisaged in the Constitution is a big struggle. My last sort of concluding point is that I think this discussion has shown us the huge challenge we have of converting this into an actionable agenda for both academic and political and policy action. And I think we have a very, very interesting and very complex task before us. And I think we will continue to work on this. So thank you very much to Mr. Sunny Kapikad, and thank you very much to Dr. Binu Paul. And once again, thank you very much, Vidyut, for for moderating this event extremely well. But I would very much like to hear your own thoughts in conclusion on this topic before we end. But thank you very much.
Yes, thank you so much, Mohan Gopal, sir. So in fact, that my light has gone. That's why I have.
Okay, sure.
So I'll just in conclusion, I'll just take 3 minutes. I'll just conclude.
Please take as much time as you like, because we'd like to hear your own views also on and suggestions. Yes, please.
Oh, that definitely I'll do in the next session, sir. I'm not taking much time because it's already 8 o'clock. Yeah. So we have exceeded that time limit. So in conclusion, that we have identified few problems, and we also identified certain pattern which is relating to the problem of caste marginalization. The first one, I would say, is that it is the existence of a particular pattern of culture or cultural format that is existing in India. And that culture is the culture of hierarchy. That culture is the culture of graded inequality, which is existing. That has caused this discriminatory experiences. And the culture also doesn't feel that they are shameful or they have to be, guilty discriminatory experiences. So the first aspect is this: it is the existence of a hierarchical culture, a culture which discriminates, and a culture which doesn't consider all human beings to be being with dignity, equal dignity. The first problem. And the second problem is those values which is generated by this cultural setting. And the most predominant values which is existing in this particular cultural setup is the value of violence, oppression, and monopoly. So we must understand that this particular culture is not supporting the value of equality, liberty, fraternity, but rather it is supporting the values of violence, oppression, and monopoly, and they are glorifying these values. They use multiple strategies for the same, as indicated by Sunny M. Kapikad, even through folk stories, folk songs, and up to the Vedic scriptures or the religious scriptures, you would say. The third thing is that how this culture and the dominant values are institutionalized. So though we have a constitution and we have a constitutional scheme to create institutions for the purpose of um, executing the values which the constitution considered to be the predominant values. So we have institutionalization. Definitely institutionalization from a legal perspective is based on constitution. From that, the next aspect comes in, the functioning of the institution. And how is this institution functioning in real life? So it is here we could see that the first two aspects, that is culture and values, indirectly operating, bypassing the constitutional values that should be the primary value for organizing our society. So upon the functioning level, the culture and values do play a major role in realizing. The next aspect I would like to emphasize is effects. So what are the effects which this kind of institutional functioning actually realizing in the society? And the effects is pathetic. That is what Dalit marginalized or caste marginalized experiences shows. And I would say that this discussions would definitely have shown that these experiences would open up the eyes and minds of those people if they do have a very neutral stand on these issues. And also they inculcate the constitutional values that we cherish. And finally, the last aspect that we need to focus is, what are the solutions then? That is the most difficult aspect that we need to explore further. And we might not have come up with any solutions for the same. But I would say that this is the most important thing. And we must examine and we must think aloud for finding out as many solutions as possible. Because this is a very complex issue. And we may not have a single issue or single solution for the same. So some people will think that, there could be a panacea for resolving these issues. Definitely not. Because it is a very complex, multi-layered, multi-dimensional problem that cannot be resolved with a single solution. So the thing is that there need to be multiple solutions at multiple levels, at multiple time, and at multiple spaces. And so we need to find out what are those combination of solutions that is required for the purpose of realizing those constitutional ideals that we have advanced, and which is the primary principle for organizing our society, which is still lacking. We must emphasize that equality, liberty, and fraternity is the primary rule. And if you have a conception of human being who is having a dignity across the board, then you cannot think about a graded equality conception and such an organization of the society. And I must say that this should be an eye-opener. And courts, particularly being a constitutional institution, court is not created through the mouth or eyes or legs of any being. Courts are constituted by the Constitution, the supreme law of the land. And definitely the court function is determined by the constitutional principles, and the personnel who is occupying the court has to play not a personal role, but an institutional role. And there is no role for the personality to play there. And the court has to play an institutional role, which is clearly defined by the Constitution. And there is no other way other than understanding the Constitution first and advancing the Constitution in the forefront to realize the goals of egalitarian society. With this, I conclude. I thank everyone who has participated in this webinar and presentation, particularly Dr. Mohan Gopal sir, and also the viewers who has been here and who is viewing through the YouTube channel as well. We have extended our time. And we are very sorry for that. It is due to the technical problems that we had in the beginning. And with this, I think we can conclude. Thank you.
Very much, Professor Vidyut, for a very excellent summary and an excellent framework, which gives us a basis for the next event we will organize on this issue. നമ്മുടെ ഹാജി അബ്ദുള്ള കുട്ടി സാഹിബിന് എന്തെങ്കിലും പറയാൻ ആഗ്രഹിക്കുന്നുണ്ടോ?
Yes, sir.
Yes.
I'm very, very grateful to attend this presentation of this evening. And if I had missed it, it would have been a very great loss, because I have seen that there is still hopes in India that justice should have to remain and prevail, because the ideas and the open speeches you all delivered is very much the need of the time, and without properly doing the justice, the integrity of the nation will not be achieved. Thank you, sir.
Thank you for your very inspiring comment. I think we have to struggle. I always say the Constitution is a site for struggle for social change, to build a society where everyone, regardless of religion, race, caste, language, region, will be equal citizens of our republic. And so I think this gives us an agenda for continuing that struggle. So I request all of us to join together to thank our excellent moderator, Professor Vidyut, for conducting this program so well. And so may I wish everyone good night. We are about half an hour. We started a few minutes late because of a few technical hitches on the streaming part, which were resolved. So I'm very glad to say that the whole program has been streamed live on YouTube. It's been recorded. In the next 1 or 2 days, we will record all the different speeches and upload them on the website of the Center for Legal Change. And we will also share them through the APA, Ambedkar PR Ayankali Legal Law Community WhatsApp group to everyone. So in the next couple of days, we will have videos up on each of the speeches separately. Thank you very much to everyone again for your support and cooperation, and wish you a very, very good night. Thank you.
Thank you, sir. With this, the meeting is dispersed.
Thank you very much.
Thank you. Bye.
Bye, Guru. Sir, we'll just leave. Okay, can I leave, sir?
Yes, ഞാൻ വിളിക്കാം വിദ്യുത് വിളിച്ചാൽ മതി. കാര്യങ്ങളൊക്കെ അറ്റൻഡ് ചെയ്തിട്ട് ഫ്രീ ആകുമ്പോൾ വിളിച്ചാൽ മതി. താങ്ക് യു.